my lord.
My lord,
My lord.
my lord, may I have your lordship's kind leave to mention for extension of interim order? One is appearing under 602
Are you mentioning upon notice?
upon notice, and all the matters I have noticed, and 2 is not appearing. All the matters
All
I
of them
have
for extension of interim order.
extension of interim order I have sub notice.
My lord, may I permit to mention, my lord?
You're mentioning upon notice? You have to mention upon notice.
My lord, may I permit to mention upon notice, my lord? I have served all the respondents, my lord. My lord, item number 344 of the, my lord, today's list, my lord, is very urgent, my lord. My land is using by the state, my lord, without any compensation, without accusation.
Give the number. Give the
My
number.
lord, permitted upon notice, my lord, item number 223 of today's
What is
list.
your urgency?
My lord, my land on the basis of false allegation, I was stopped to extract sand from the mining lease. Subsequently, I have been acquitted from the criminal case, and by this time, 3 years they have taken from my tenure, my lord. So I have faced my huge loss, my lord.
Well, day before yesterday,
Consideration.
I prayed for leave, my lord, on moving the urgent motion. Your lordship directed me to file it and give the number. My lord, urgency is this, my lord, on 16th, my lord, the my lord, tender process. Yes, yes. I have given notice to all the parties, my lord. May it be appear on tomorrow, my lord. Kindly, my lord.
Shantanu, let calculate list.
My lord, grateful to you. New motion, new urgent motion. Grateful to you.
My lord, may I permitted to mention, my lord, upon notice of daily list, urgency is granting a permission for no objections and no objections for exit and exit and entry of the main road of PWD ground.
My lord, sir, may I permitted to mention, my lord, on 24th, my lord, 13 matters was adjourned and then was rejected to matter appear on 8 on the urgent mention matter. My lord, unfortunately, the matter appeared, but not in the mention matter. In scatter
On the second day, it will never appear in the mention matter. Mention matter only one day. Then it goes back to the motion.
That is adjourned, my lord, on the prayer of the learned advocate.
Maybe, but it will again not appear in the mention consciously done.
Lordship's order, the matter appear on again on 8th. Lordship kindly appreciate. Lordship's passed an order in the mention matter. That is not in the mention matter. My lord, kindly appreciate all the matter, my lord. Same one order which can be passed.
It is beginning to mention.
My lord, may I be permitted to mention one matter, my lord? It is regarding the SDO is not complying with the order of the coordinate bench of this honorable court, and the petitioner have filed one contempt. They have issued a rules and they have complied that, but till they have not removed the encroachment on the petitioner's land.
It's an order of the coordinate bench, you say?
Yes. Yes, my lord.
It's an order of the coordinate bench.
Yes, sir. My lord.
To approach the coordinate bench.
My lord, complied. Contempt have been complied.
Yes.
But they have given the reason. But till now they have not removed the encroachment.
Are you mentioning upon notice to the other side?
My lord, it was filed yesterday only.
Please mention.
My lord, with notice, my lord, I am praying for upgradation.
Urgency?
My lord, petitioner's egress and egress has been blocked by the private.
May I permit to mention one upon
Possibly,
notice?
1st December 23, this notice under section 10(1) of 1964 Act has been issued, but the notice has been delivered to the shop room, alleged shop room, on 8th. Now it has been stated within 10 days these shop rooms will be demolished. Now this is issued by the assistant engineer. Let's kindly take this matter tomorrow. Let's see, all our state respondents. In the meantime, I'll serve.
What is that? What is your urgency? Because 10(1), it will not be demolished. You have
10(2), 10(1). Let's see, this is a content of the notice that within 10 days, if you not demolish, they will be compelled to demolish.
What does the act say, Mr. Mukherjee? You are aware.
Let's see, kindly see the notice.
I'm aware. Yes. Even
I know, let's see, unless 10(3) is there,
yes,
they cannot demolish.
Yes.
But let's see, these are contents of the notice. Within 10 days, if there is no self-demolish, on the next day, these alleged shop rooms will be demolished.
You are aware that that doesn't happen. There is 10 till 10.
Let's see, kindly if these shop rooms are demolished, then what is the fate?
It cannot be demolished before 10(3), sir. You are aware. And the court will not entertain.
Let's kindly see the assistant engineer issued the notice.
That is the normal language. That's the normal language of the notice.
Let the some protection be status quo in regards.
In fact, the writ petition is liable to be dismissed because it's premature.
Lordship,
Then
the
come only after
contents of the
10:03.
notice, not only that, Lordship, I have
It is
made out a
appearing in the
case. I have made out a
Is it
case.
appearing in the list?
No, this is, I'm praying for unlisted motion.
No, not at all.
Lordship, may I permit?
Please file and come back. It will
Lordship,
be an order.
now, Lordship, if I file,
Petition
it
is
will be
required.
listed on, Lordship, Tuesday.
Yes, yes.
Lordship, let this leave may be granted to leave,
Nothing, Mr. Mukherjee, I'm sorry. No leave is
yeah,
required.
only for listing on Monday.
No urgency at all in the matter.
Lordship, the 10
And
days will
please-
be over.
Twice before you file, because this is liable to be dismissed, I'm sharing a piece of my mind here and now.
Lordship, the land which
Next
are
matter.
Soprum
sorry,
is
Mr.
running, this is a private land.
Maybe, I'm sorry. Yes, next.
May I permit to
Lordship,
mention
maybe
one
Tuesday
upgrade?
at least,
You have to
Lordship.
wait. Nothing. Please file and it will come in the usual course. No urgency at all. And before 10:03, the court will not entertain also. Yes.
Lordship, may I permit to mention one upgradation, your lordships?
Yes.
It's a matter regarding your lordships, sand mining, your lordships. Petitioner at its own cost, your lordships, excavated land from his leasehold property. Thereafter, same was stocked and
Are you mentioning
selling.
upon notice to the other
Yes, your
side?
lordship. Yes, your lordships. Later on selling on, but in the meantime, your lordships, lease was expired. But thereafter, your lordships, petitioner made a representation to consider only stock land, your lordships. Thereafter, lordships, the concern did not.
Land.
Yes, your lordships.
Stock land, what is that?
Stock sand, your lordships. That was not considered, your lordships.
Give the number.
Lordship, may I permit to mention for the upgradation upon notice and for the petitioner obstruct the petitioner ingress and egress way.
Give
2 matters, Lordship.
An extension of
Same issue?
Yes.
The matters?
extension of the
Brother.
interim order, Lordship.
Upon notice?
Lordship, kindly consider because the interim order is expiring 2 months.
Have you served notice? Are you mentioning upon notice? So you have to mention upon notice, sir.
Interim order is
First line of my list, the first page of my
but
list.
it's urgent because
You
the
could have served in the meantime in that case.
start today, Lordship.
You have to mention upon notice.
Your Lordship, may I be permitted? Your Lordship, I had previously mentioned this matter before Your Lordship on the 11th.
Are you mentioning upon notice?
Your Lordship, this is a contempt application.
Fresh new contempt?
Fresh new contempt.
Notice has not been served?
No.
Give the number. Yes, call the days list, please.
Your Lordship, Your Lordship had previously allowed this mentioning, but however, it has not come up in the list. The main writ is returnable on the 11th of January. But there's an urgency because the interim order, despite being in operation, the state respondent are
It'll appear. The matter is fixed on 11 January.
11 Your Lordship, the main writ petition is returnable on the 11th of January. Your Lordship, I have filed this contempt application because despite the interim order, they are proceeding with the construction.
No.
The interim order is
Contempt এর মধ্যে রেখে দিন। শুধু contempt.
obliged.
My lord, may I permit to mention this is the very urgent matter, my lord. Petitioner is a 80 years above. His land is.
Are you mentioning upon notice?
Yes, my lord, this is the notice.
What is your urgency?
Urgent is land was acquired by the Jila Parishad, my lord, without notice or without hearing and without any notice. This is 80 years here old, my lord.
Give them. Yes, call the days list, please.
For judgment item number 1.
We are only here before a lordship.
Yes, the writ petition has been allowed. I'll read out the operative portion. In the present case, since the petitioner has been deprived of her property by the state without resorting to procedure prescribed by law, she is entitled to compensation for the same, along with other statutory benefits, including solatium, interest, etc., treating it as a case of deemed acquisition. In other words, the property of the petitioner is deemed to have been acquired by the state, and the petitioner is entitled to compensation as well as other statutory benefits. The writ petition is allowed. The respondents are directed to pay compensation to the petitioner at the present market rate, along with all statutory benefits, including solatium, interest, etc., within 2 months from the date of communication of this order.
Solatium.
Solatium, interest, and all other statutory benefits.
After a long time, we have succeeded before a lordship.
This is a 2017 matter.
তুমি কালকে 10 লাখ টাকা দিয়ে দিবে।
Shantanu? Sure. Temporary. Yes, next one.
Item number 2.
Private respondent number 9 in this matter.
My application for extension of
I
interim order
oppose the
can
prayer.
one.
Can you look at the order?
Yes. Yes. Order is at page 9. The operative portion at page 11. I'm sorry, madam.
Page 11 of?
Page 11 of my CAN application, madam. CAN 1 of 2023 connected with WPA 18190 of 2023.
What is the CAN about?
Extension of interim order, madam.
When has it expired?
But it has not expired.
It will expire tomorrow.
My lord.
There are two conditions in the interim order. First of all, the state to file a report.
CAN 1. Yes.
First-
Mr. Gottabal.
Report এসছে?
We have filed an opposition.
Affidavits are complete.
My lord, the condition was the report is to be filed by the state. And although exchange of affidavit should be made, the time limit fixed for filing affidavit is 4th of December. We have filed that before that event.
Affidavits are complete.
And he has not used the reply. And he is wanting the extension. Reply was time bound. He has chosen not to file the reply. He has not filed the reply. How can he pay for extension of interim order?
I'm told that it has not been served, but in any ways, even if
Now,
they have
I
not,
have a receipt.
even if that be so, my lord, let this matter be heard
This is
out
the receipt showing
tomorrow
service.
itself. We don't have a problem, and if
It is not at your discretion. Court's discretion is.
no, court, of course, court.
Court's convenience will
But why will this interim order not be extended?
should not be extended because of your latches. You have not used any reply to me.
Even if he doesn't use a reply, the matter.
Let
will
not
be
his
heard
lordship
out.
take up the matter. 273 regulation will apply. Here he cannot ask for the pisciculture in respect of the land, my lord, non-vested area.
My lord, they have a
দাঁড়ান, বলতে দিন আমাকে।
expired lease of
ঠিক আছে।
water bodies, but there is an expired lease. They want their
Let the
rights.
matter be fixed for hearing,
My lord.
then the interim order will be extended.
Deeply abused.
But 17th is the date the connected writ is fixed by your lordship. Let it appear on 17th with the number, same number I am
Sure.
giving. 17th of January, lordship already fixed.
Sure.
17th is
But I'm told that the opposition has not been served. I'm
এই তো,
I'm
এইটা কি?
instructed
এটা
by
কি?
my
এটা
advocate record
এটা
that
দেখা না,
the
কেন
opposition has not
এটা
been
দেখো,
served.
No, কোন রিসিভ? কে রিসিভ করেছে?
এটা কি?
কে? We are not PK tomorrow. No. Advocate recorded Shahiduzzaman. Why?
They are lying before the court. I should say. They are lying before the court. What is that? Can it be expected that the receipt given by the advocate's
Other
office
7th January.
17th of January?
This is not even served on us. The letter is addressed to somebody else. It is
এটা
not
কে?
even addressed to my.
Shahid Jaman কে? Care of Pradeep Kumar Tarafdar কে? Hastings Chamber, who is he?
Advocate record the size jump.
Advocate record is Shahid Jaman.
Sure, এটা receive হয়নি।
এই তো advocate record Shahid Jaman.
জানি না, উনি বলছেন তো রিসিভ হয়নি।
This is also fixed on 17th, so no further date is
Sir,
required.
my lord,
There will be an extension.
my lord.
Receipt দাও।
What are you mentioning, sir? The interim order is extended till 31st January 2024.
My
That was
lord,
the
my lord, that is a different
correct
petition.
matter.
My lord will kindly take up WPA 18190 of 2023. I have filed a CAN, that is CAN 1 of 2000.
Three matters are running analogously,
My lord.
so the interim order is in all the matters.
No, my lord. This is a writ petition 18190 of 2023. This is our writ petition, in which we have an interim order that they will not interfere with our pisciculture. In their writ petition, they have an interim order that we will not interfere with their pisciculture. So both the interim orders are different.
And state has given a notification that they are not entitled to catch fees over there. They are only
No,
entitled to.
that
That is the
is
273 is their law.
no.
I just show you.
Record one line, the interim order passed on this date shall hold good for all the three matters.
My lord, all the three matters, my lord will kindly for once.
Three matters
But
টা কোথায়?
একটুখানি দাঁড়ান। For once, my lord will.
Not
এটা
There are
item
two
number
matters.
কত?
police inaction matter. That is a police inaction. In any event, lordship.
বলে, এত
Keep it
বেশি
on 17th, my lord, the day fixed. Let it be heard on 17th.
All the three matters together.
My lord,
Let-
my lord, fix all the three matters together in regard to the interim order of 1819.
Fix, sir, please understand.
My lord, my lord.
There is no further order required at all. The three matters have been taken up together, a common order is passed in all the three matters. So there is no difficulty.
My lord,
ঠিক আছে, একই order থাকবে।
my lord will kindly extend it for, my lord will make it a,
Vacate it now.
I'm sorry, my lord, I'm sorry.
Matters, same order is covering all the three matters. There is an interim order till 31st January. What is your difficulty?
But this is a matter in which I am enjoying an
Yes,
interim
so
order.
in all the three matters, the interim order is effective, isn't it?
No, my lord, my lord.
I'll
don't
just reckon
get-
that
All
time.
my lord will extend it for all the three matters till the
Not
next.
extended, already extended.
No,
No,
not
further extension.
Can one of 2023 না? Can one of 2023 তে order করুন? Since the interim order has been extended till 31st January 2024 by an order passed on
নামটা দিয়ে
5th
দিচ্ছ আবার। Right track
December
থেকে পাবো।
2023, comma, the said order is applicable in case of all the three writ petitions
এইটার
which
একটা
are under consideration analogously.
বলতেই পারি।
কি হয়েছে কি বলো? ও সব ব্যাপারে।
Stop, no further order will be passed.
Action no, নিচে continue।
Can
ধন্যবাদ।
one of 2023 is disposed of? Date already আছে.
Interim order, my lord has extended it till
Please
70.
see the order. I have explained many times. Please see the order. Next matter.
Grateful to your lordship, চলো।
No order is needed, pass করে দিল তো। আরে সেটাই তো বলছি। বলবি? হ্যাঁ বলেছি আর পাশ থেকে এতবার করে এত
Next matter.
বলছি।
I'm for the petitioner lordship. I'm praying non-prosecution. Client send me the written instruction.
বলছি তো। আরে বলছে এইটাকে স্পেসিফিক্যালি এক্সটেনশন বলছে all three matters 31st অব্দি আছে বলেছে। তাহলে বলেছেন
Learned counsel for the petitioner submits that the petitioner does not intend to proceed with the matter any further. Paragraph written instructions submitted by the petitioner is taken on record. Paragraph in view of the above, the writ petition being WPS such is dismissed for non-prosecution. Paragraph, there shall however be no redress to costs. Next,
Grateful lordship. Lordship, kindly urgent certified copy.
করলেন তো? Urgent certified will say yes, yes.
Item number 6.
My lord, it has come up at my instance for extension of interim order, my lord. The initial interim order was granted on
Hearing matter.
not really, my lord. On last occasion, 16th of October, the NHA authority, respondent number 225, have been directed to file a report. My lord, for my knowledge is
Actually,
concerned.
my lord, actually, I have sought for certain documents from the KMDA lordship, from the through a letter dated 6th October. Lordship, that documents are still awaiting, my lord. Without these documents, my lord, I am unable to produce, lordship, any kind of records before your lordship. So, lordship, I need 3 to 4 weeks time, lordship, to file my opposition, my lord.
My lord, KMD authority respondent number 1 has already filed a report, and so far my understanding of the report is concerned.
Motion stage. A report was called for from man.
My lord.
We have filed our report. We are responding number 5
So let the interim order be extended for some time.
for a limited.
Learned counsel for the National Highways Authority of India seeks further extension of time to submit the report in the form of affidavit as sought. Paragraph, report in the form of affidavit be submitted within 2 weeks after the vacation?
My lord,
Or
my
little
lord,
more?
my lord,
Yes,
my lord.
within 2 weeks after the ensuing vacation. Paragraph, let the matter appear under the heading motion on 29th January.
Grateful, my lord.
Paragraph, is it a short matter?
It's a short matter.
Or I have to extend it till February in that case. Let the interim order paragraph, the interim order granted earlier is extended till 29th February or until further orders, whichever is.
Grateful.
Item number 7.
Lordship, day before yesterday,
Our application,
yes,
my lord, the contempt application, your
day
lordship.
before yesterday, I mentioned before the division bench for early hearing of the matter. Lordship, division bench fixed on fifth January. I do not know, up to Lordship to do what to do. 5th January, they have scheduled.
My lord,
Very good.
on 29th, lordships.
Appeal was filed in time. That's all. Day before yesterday mentioned 5th January, division bench fixed the matter, especially fixed. I do not know next. Lordship, pleasure, Lordship.
My lord, kindly see the record, my lord. Order was passed on 29th November. Adjournment short for they themselves.
Yes. I filed an appeal in time.
Next date, my lord, they have sought for.
Yes.
The 14th November and December. And they have filed the stay application on 12th. My lord, kindly see.
Appeal file in time, Lordship.
Appeal file in time. That's a memo of appeal. No service,
Sir,
nothing.
memo, last day before your court.
Sir, copy of the appeal, the memorandum.
Lordship, before this, perhaps Lordship in the court, Lordship, they handed over to Lordship in the court file. Lordship, handed Lordship in the court.
12th of December.
Lordship,
stay of application has been filed and
Lordship,
fixed up the date on 14th November.
Lordship,
14th December.
Lordship,
fully well that the next date is fixed on 14th December.
Lordship, memo last time my learned friend handed over.
The worker.
Lordship, last time my learned friend handed over memo to your Lordship, in the perhaps in the Lordship file. Memo. Last time I handed over. In the court, I handed over.
If there is no stay order, I'll proceed with the application.
Then I will fill again another application for staying this.
The can 2 was disposed on 31st August.
Yes, I remember. If there is no stay in the meantime, the matter will proceed. Let me make it very clear.
Another court not proceed, Lordship proceed. I don't know. Another court no court proceed.
This court.
No court, maybe Lordship. Another court not proceed.
Supreme Court has said if there is no stay order, the court can proceed.
Yes. No court, every court.
Law by now.
Yes. Lordship, there are some different view. There are different type of judges.
No.
This, Lordship.
Come up with your different view on the next date if you are not ready. Otherwise, I'll proceed.
Memo, Lordship, Lordship, memo I handed over.
Kindly pass an order, my lord.
Learned counsel for the alleged contemner submits that
on 5th January matter.
The matter is fixed for hearing before the Honorable Division Bench. The appeal is fixed for hearing.
Yes, Lord.
No notice. No notice.
I mentioned.
No notice. Let them show that the notice has been served, saying that the matter has been fixed on 5th of January. It's a blatant lie.
Memo last time handed over you. You have handed over to court. You have handed over the court to
paragraph, let the matter appear under the same heading on 22nd.
They have not served the Union of India, the most vital party.
You have not served the Union of India.
I handed over. Served Lordship day before yesterday. Office hai. I handed over to office. That's the system.
I do not know whether he is.
I will not serve 50,000 cost to me. I will know you also.
Record is submitted.
Lordship, in the memo last time, my learned friend handed over to who?
Come back on the next.
Lordship, my return to my learned friend, and the learned friend again said not handed over.
Next one.
Memo last time আপনাকে দিয়েছিলাম, আপনি কোর্টে দিয়েছিলেন। কোর্টের মধ্যে মেমো আছে।
Next date fixed on
22nd January.
মেমো আপনাকে লাস্ট টাইম দিলাম, আপনি কোর্টে দিয়ে দিলেন, আমি কোর্টে বলতেন কি না। আপনি বলে খালি শুধু মেমো দিয়েছেন।
Next.
Number 8.
Still continuing.
I start this item number 8. And this lordship order already complied.
Complied with?
Yes.
You are for the petitioner?
Yes, ma'am.
Learned counsel for the petitioner submits that the order under contempt has been complied with by the alleged contemptor. Paragraph in view of the above. The contempt application being such CP and such is disposed of. Paragraph, there shall however be no orders of costs as in certified second.
Affidavit of service to the.
Item number 9.
My lord will come straight away to page 621 of the brief, my lord. My lord, that's the order of my lord, and I have served, my lord. That is there is my affidavit of service.
Mr. Mahathir is appearing.
I am appearing on behalf of the one of the contemners.
But there are 3 contemners. Now, my lord, so far as alleged contempt number 1 is concerned, my lord, new incumbent has came in, my lord, he has been added as a party as alleged contemptor number 3. My lord, today, my lord, the alleged contemptor number 1, my lord, he intentionally did not comply the order. I will show. And now, my lord, he is out. He has demitted the office, my lord. So, my lord, today, my lord, first prayer is, my lord, a rule be issued against the alleged contemptor number 1. Because now he cannot also comply. He has demitted his office. But during his tenure, he has not complied the order.
Where is the affidavit of compliance?
Well, first part of the order has been complied with, my lord. So the second part of the complaint regarding payment of compensation, my lord, that has not been complied till now, my lord.
That I am led by Mr. Shanna.
But I am trying some more time, my lord.
88 years old, deliberately. কোনো contempt proceedings হয়েছে সেখানেও same জিনিস করেছে।
What is the first part and the second part?
My lord, and after demarcation, it has been found.
My lord, may I make one submission? So I'm for the applicant. My lord, let them come up with a compliance report in the reopening your lawsuits. Because this is further contempt on their part.
Say that the measurement has been made.
Yes, my lord. Demarcation has been done.
And that's long ago, my lord, accordingly.
It is found that there is a photo utilization.
No report supplied to us. That was, if I'm not wrong, 2nd August.
You were directed to take steps for assessment of compensation.
Yes, my lord. That part has not been complied.
How long, how much more time do you require?
It will appear 1 week after vacation, my lord. In the meantime, we shall file our complaint.
In the meantime, you'll find a compensation. Let them come back. Because I intend to issue rule.
That's also, I also.
My lord, I am appearing on behalf of the alleged contemptor number 2. My lord, I have not given the details of, my lord, that we are ready to acquire, we are ready to make payment of compensation, but we have not given the details. We are the, my lord, the PWD engineer.
That's true.
You are alleged contemptor number 2.
Alleged contemptor number 2.
The land acquisition.
One assessment board compensation. One করতে পারবে না,
If your lordship kindly come, my lord.
My lord, therefore, kindly see your losses do not have any explanation from the respondent number 5, who is now the contender number 1. Your losses will find that inspection was made with notice to us. Your losses will find. Second, so that part is over. Now he is sitting tight with that. He has now to file a copy of the order to the 1, so that 1 can make an assess, 2 can make an assessment.
Affidavit of compliance should come on the next date. And compliance in its entirety. No part compliance will be accepted. Statement of facts submitted on behalf of the second respondent is taken on record. Learned counsel for the second alleged contender respondent, second alleged contender. Learned counsels for the alleged contenders seek accommodation to comply with the order under contempt in its entirety and file affidavit of service on the adjourned date. Paragraph, let the matter appear under the same heading on 11 January. Sufficient time, please comply with the order. Next.
Item number 10.
Yes.
Miller, on the last occasion I have submitted, I have placed before your lordship all the documents in support of my claim, barring, my lord, the impugn order. Now, before I move to the impugn order, at the cost of repetition, I like to draw your lordship kind attention to page 204. 204.
There was a challenge to maintainability.
Manoj?
Maintainability. There was a challenge.
Oh, no,
to
subsequently he said, I will not
My
place
lord,
that.
because my lord, with, on that day, my lord, I am not with, my lord, my learned friend has already started his.
Yes, yes, he has made his submission.
Yes, my lord, only for that is my lord, I take that point at the time of hearing, my lord. I am coming with that point, but that is the main point is that, my lord, but for limited, only for that is my lord, he is go on. তুমি বলো।
No, my lord,
তুমি বলো তোমার।
kindly turn to, my lord, the
কত কথা বললে?
204.
কত কথা বললে?
Page 204. My lord, this is the order of the self-same authority earlier. Against whom, my lord, I moved a writ petition before Justice Talukdar. Justice Talukdar said that I am entitled to have the compensation. I was directed to make a written representation. I made. Now, my lord, lordship, kindly turn to page 2041.
Yes.
This is from, my lord, 1, 2, 3, 4, 5, 6, 7. Seventh line from top. But no subsequent record is available. Your lordship has got it.
Yes.
Available after passing of nearly 40 years. The petitioners also failed to submit any confirmatory proof. Hence, the claim of the petitioner fails. Regarding claim of their house, Sebasriti, situated on the plot number 2542 of the Asansol Mauja, he could not show the original Rayati Khatiyan to me. On the contrary, the said plot number is found in Appendix 1 such and such of the petitioner as the property of North Kosekurari as a Dakholdar. Hence, the claim of the petitioner fails. Now, this has been set aside by the Justice Talukdar as well by subsequent order as well as by your lordship. Now, my lordship, kindly turn. I have shown to your lordship the entirety of this. Now, lordship, kindly turn to the impugn order.
At page?
At 8th page, my lord. At page 3, my lord, 300 start from 310. My lord, kindly skip over the 311. Now, my lord, 312.
Yes.
Now, this is the order number 1. There he has quoted your lordship's order and said that your lordship was directed him to revisit the decision. Now, my lord.
Oh, sorry. একটু পরে শুনছি। কত কথা দেখাচ্ছ?
Then, my lordship, can you turn to order number 3 at page 313,
Yes.
9/3/2003. All along they took this plea, my lord. This is a property belonging to the colliery and vested with the state under section 29. This was the submission before your lordship by Mr. Sengupta as well. Now can title of the said land were changed in favor of the Public Works Department, West Bengal, without the process of law. My lord, this is a foreign thing that has been introduced. This is not my case anywhere, anytime. And without any basis of the records, my lord, there was no such submission on our part as well. Now he has recorded this and proceeded with this. Then, my lord, kindly see West Bengal without the process of law, and petitioners claim that the payment of compensation already made to the other standing on the same footing for the said acquisition by the state of West Bengal for the public purpose and required to be paid compensation in respect of said land. The petitioners are asked to produce the documents support of the aforesaid representation made by them on 16th of January. The petitioner cannot produce document in support of the representation. My lord, all along I have submitted. Your lordship as well as the Justice Talukdar also said that already Khotiyan or everything I have submitted to them. None. Then, my lord. Then, my lord, next, my lord, at page 5.
Page 5.
order number 5 at dated my lord 314, page 314, order number 5 dated 4th of April 2023. In the meantime, any documents either from SDLRO EP1 or from the petitioner has not been received. Another letter is issued by memo number such and such, addressed to the learned advocate on the petitioner for providing the documents in support of point number 8 and 12 as made out in the representation at the earliest. Today, this office has received the reply against the letter issued by such a number from the learned advocate on behalf of the petitioner. After scrutiny of the case record, it appears that Eastern Coalfield Limited has issued a letter addressed to the Special Land Acquisition Collector dated 87 and appealed for rectification of ownership in favor of ECL in respect of the suit plots by virtue of Coal Mine Nationalization Act. Kindly mark this portion, my lord. I am nowhere in the party to this. There was no proceeding I submitted before your lordship under section 44(2) small a.
Yes.
For correct review of the retention order. Nothing sort of this. In spite of that, they are proceeding with this, my lord. And my lord, your lordship has I categorically submitted, and your lordship upheld that. That's so far the surface land is concerned. That is my claim. So far the subsoil part is concerned, my lord, I don't have any claim. I cannot have any claim.
That is your case.
Yes. Then, my lord, lordship kindly see. Next order number, my lord, 7. The case is put up today for hearing. The learned advocate on behalf of the petitioner and performer respondent are present and file hazira. The representative of the ECL is also present. The learned advocate presents the arguments in favor of the claim as the landowners of the suit properties are based on RS record. But he cannot produce any document of LR record. The question does not arise. Because you have constructed without any proceeding, according to me. Now I will show from the record, my lord, their report that proceeding was initiated, in fact initiated. And I was not paid compensation in respect of the suit land. So meaning thereby, my lord, the moment the acquisition proceeding initiated, they will not record my name in the LR record right. In the meantime, my lord, this office has received the LR record of the suit plots from the office of the SDR Asansol, which are made a part of the proceeding. The observation are as follows. The Honorable Court directed the undersigned to revisit the case in the light of observation made in the said judgment as well as the order coordinate bench in the 2008. Gone through the judgment of the Honorable Court bench, where the Honorable Court clearly mentioned that it is for the read to establish their claim with relevant document as indicated earlier. But I will show, I have shown to your lordship, my lord, the judgment and culminated the judgment of your lordship. Then, my lord, during revisiting the case, the undersigned feels that the LR record is relevant document to ascertain the recorded owner. My lord, my respectful submission before your lordship is it, record of it does not confer any title. It is merely for the purpose of, my lord, if there is a contrary challenge, my lord, then that cannot be said to be the sacrosanct so far the ownership part is concerned. I have shown to your lordship, my lord, the order under section 6. Finally published record is certified under section 44(2). Then, my lord, the proceeding was initiated by the year 1976. 1976-77, kindly mark that portion, my lord. But the read petitioner produced all the documents issued in their 1969 arrest record. What more I can produce? Then, my lord, kindly see. After scrutiny updated LR record received from the office Asansol, the status of the record as follows. Then, my lord, your lordship, I shown to your lordship, my lord, the 2540 so far my residential plot is concerned. There is no whisper even in this judgment also. Now, what is did, my lord? Vested to the state, vested to the state, vested to the state. Next is very important, 2515, National Highway Authority of India. My lord, may I put it to myself? Until and unless this property is being transferred by way of acquisition, acquired and transferred by your deed of transfer, it cannot be the property of the National Highway Authority. And moreover, my lord, the law is the vested land cannot be acquired. Now, my lord, why I am saying this? My lord, this is the impugned order based on which my claim for compensation has been rejected, which has no foundation. In fact, they are repeating their whole the exercise on the basis of the section 29 of the State Acquisition Act. That's why I say all along saying that vested. then my lordship kindly have a look at the report filed in this case. Everything will be clear by your lordship, to your lordship, my lord. Only I will place just last paragraph of this report. That is dated nil, my lord. At least in my copy, there is no date.
The brief history.
A brief history.
This is the report.
This is the report. Now, a brief history pursuant to lordship direction, this has been filed. Now, the last paragraph. I am skipping over all the things. Meanwhile, the last paragraph of the report, my lord, of the brief history, last paragraph.
It is pertinent to mention.
No, no. No, my lord, the last paragraph, the first page,
First page,
last paragraph. Sorry.
Right,
My lord,
yes.
sorry. Madam, meanwhile, in the year 1976-77, the acquisition proceeding of area 4.73 acres, including the shoot land, had been initiated. Kindly mark this. By order number such and such, this should be, my lord, cannot be the order number, this should be the case number. Under Act 2 of 1948, for the purpose of construction of road overbridge and Ghotak Mozla Eastern Railway main line for the existing Kositapur Mouja, Asansol District, Bardhaman. So therefore, my lord, their whole story in rejecting my case cannot be sustainable in the eye of law. Because it is their own admission for in respect of my claim, they have initiated a proceeding. Earlier, twice they initiated a proceeding. I was paid compensation. This time again, they initiated proceeding. They never disclosed this. For the first time, they disclosed this before your lordship. Yes, suit property has been acquired by way of proceeding, acquisition proceeding. If this is being acquired, it cannot be said to be the property of the state of West Bengal. Cannot be the property of the collector or property of the government. Because government cannot acquire its own property. And admittedly, my lord, my residential plot is concerned, my lord, where my residence is situated, where they forcibly 2542. No whisper, nothing. Although, my lord, I shown to your lordship, there was a challenge before the time and again I've challenged that thing, my lord. And only saying this, they are saying that I have not produced any document. But that is for the cost of my reputation, my lord. Kindly see, my lord, once again the paragraph 2540, your lordship will find at page 100. Just a minute, my lord. Page 100, your lordship will find that. No, just a minute, my lord. Just 1 minute, my lord. I will conclude my argument. 101. Kindly turn to my lord 101. This is the, my lord, the certificate 101 2542 Bastu. 2542 101.
Yes, you've referred to this.
Yes, Bastu, and this is certified under the State Acquisition Revenue Officer, under the State Acquisition Act, under Section 44(2).
So it was written.
Yes. And he said no. Although on the other hand, he has accepted that there is no document there, he is proceeding with my document. And your lordship, as well as Justice Talukdar, categorically said, whatever document I produce, they will proceed with
Where
this.
are those two judgments?
Yes, my lord, if you have Justice Talukdar judgment, your lordship will find at page, my lord, 206. 206. 206, my lord, your lordship will find Justice Talukdar judgment.
And this court's judgment?
Yes. This is the,
294, I think, isn't it?
my lord?
294 is the other judgment.
The 206 by Justice Talukdar. Justice Talukdar initially, my lord, there was I shown to your lordships the order of the special acquisition officer that has been set aside with the entire process of constitution must be complied with the 8 weeks from the such and such. Now this is after taking into consideration of the relevant facts and material and submission made on behalf of the writ petitioner, I find no reason as to why the present dispute has to be kept alive for such a long time. If for the purpose of construction of flyover of the same lands have been acquired, and if the petitioner established their claim that they are the owners of the said land, It was thus acquired for the public purpose and they are required to be paid compensation. And moreover, my lord, your lordship has dealt with this, considered this judgment, also negated the subsequent the order passed by the special LO.
That is 294, isn't it?
Yes, your lordship's judgment is, my lord, at page 294. That is your lordship's judgment. There, your lordship set aside the story of vesting entirety. Well, if your lordship, for just for my satisfaction, once, well, kindly turn to page 206. Last few line of the judgment of Justice Talukdar. 206.
Yes.
The authority concerned seems to have not taken into consideration the fact that the flyover in question is admittedly situated on the aforesaid plots, which is recorded in the name of the predecessor of the petitioner.
Yes.
And now they have come up with a fact that suit plots that may acquired in connection with the proceeding initiated under the Act 2 of 1948.
That was not stated in the earlier writ petition.
Nowhere. This is for the first time. My learned friend will correct me if I am wrong. That's why, my lord, nowhere either your lordship's order or Justice Talukdar or
Not reflecting. Yes.
not reflecting. So therefore, my lord, this
In all these orders, it was only with regard to the subsoil and the surface.
all along they have proceeded with that land has been vested under section 29 of the West Bengal Estate Acquisition Act, both surface and subsoil. So my respectful submission before your lordship, my lord, that this impugn order should be set aside, and with the direction, my lord, not kindly don't remand it back to me, my lord, to the further. I direct them to initiate a proceeding under the 2013 Act. So far my property, house property is concerned, and other properties are concerned, if the compensation already been paid. Because there cannot be any award to this, because they took the two contradictory stand. Once they are saying proceeding initiated, but there is no whisper award or something like that. So therefore, my lord, after 1997, there cannot be award under Act 2. Subject to the, my lord, proceedings under section 401. I don't know why there is no whisper to this, how this has been acquired.
There is no whisper of award also.
There is no whisper of award.
Only one sentence that it has been, proceeding was initiated, that's all.
Yes.
There's
I
nothing
thankful to
further.
my lord, senior friend, my lord. At least they have written this for the first time.
But only one single line, I don't find anything else.
Nowhere. Yes,
Yes,
madam.
My lord, I first starts with his petition, my lord.
Yes.
With his petition.
Yes.
That is paragraph 2, my lord. That is the originally they said that is the Sushil Kumar Mukherjee was the original owner of the land, my lord. That is paragraph 2 and page 5, my lord.
Yes.
And all the records are, my lord.
GHOSH.
Up to the RS record, they are getting their name, my
This is
lord.
admitted. This is not in dispute.
No, my lord. That is not. And those are in the. Now, my lord, paragraph 3, my lord, that is the how they are after the death of the Sushil Kumar Mukherjee, how they are dealing with the case, my lord. Now, my lord, that paragraph 4, my lord, that the purpose of construction of the NH 34 by passing a national the then collector Bardwan initiated proceeding under West Bengal Land Requisition Acquisition 1948 at present expired. After that, in a case number 1963, accordingly, a vast area of land measuring about 9.62 acres of Ato details were requisition and were Ato subsequently Paschim Bardhaman by issuing notice under section 3.1. Now, my lord, paragraph 5, that is subsequently for the purpose of construction of that is the collector Bardhaman individual initiated another proceeding under the said Act 1948, LA Act of 18R, and accordingly the area of 0.97 aforesaid plots as mentioned in paragraph 4, wherein upper RS plot number 10 and 48, my lord, that was Bardwan at present Paschim Bardhaman, RS plot number F1 Ato Asansol, District Bardhaman, issuing a notice under section 3(1) of the other. Subsequently, for the purpose of construction of National Highway, my lord, that is another notice is there, my lord. I may not want to. My lord, that is paragraph 7, my lord. Total area is, my lord, 15.23 acres of land were acquired and compensation whereof were paid to the said Lalit Kumar Mukherjee. Acquired and compensation were paid to the Lalit Kumar Mukherjee since this is Lavanya Mukherjee and other. That sometimes in the year 1974, the then collector Bardhaman forcibly took over possession of the land as mentioned in the paragraph, measuring about 84.4 acres of land of the Atho without initiating any proceeding, whatever in the nature, without payment of compensation to the Atho and possession of the paragraph 8, my lord. It is stated that is paragraph 9, my lord, that is the respondent were taking any step without the repeated request for the compensation of the petitioner, along with the pro forma respondent hearing, moved an application under Article 226 of the Constitution of India and West Bengal before the read in the nature of mandamus, my lord, that is paragraph 9. Now, my lord, paragraph 10. Now, in the aforesaid petition WP Namato, Justice DP, Honorable Justice DP Kundu, my lord, was the then 11th June 1992. His lordship was pleased to dispose of the said petition. Learned advocate for the petitioner submits that the respondent number 3, Land Acquisition Officer Bardwan, be directed to read a copy of the writ application of the petitioner, consider and dispose of the same in accordance with law. It is in order. That is first order, my lord, starts from Justice DP Kundu to consider and dispose of. Under the circumstances, dispose of the petition, dispose of the respondent number 3 is directed to treat a copy of the writ application, consider and dispose of the same law by affording fair and reasonable opportunity or oral hearing of the petitioner and all other interested person and parties, including the other respondent, by reason order with 6 weeks. A copy of the same served with the petitioner within 2 weeks from the date of making thereof. The learned advocate for the petitioner is directed to take down the gist of the communication of the same, my lord, within 2 weeks from the today. That is, after that, my lord, that in compliance of the said order, 11 June, by memo number Atho dated Atho, the special land acquisition officer Bardwan directed to the petitioner to appear. That on or about September, that is the paragraph 13, my lord, issued a special land acquisition officer Bardhaman, whereby a copy of the order dated Atho allegedly passed by him was forwarded by to the petitioner by the said alleged order. Claim your petitioner for compensation was rejected in a mechanical manner and without proper publication of mind and without appreciating the true nature and act of the same, my lord. That is the order, my lord, 2002, page 2002, my lord. Page 2002, my lord.
202, yes.
202, yes, my lord, 202. The reason order of the LA collector is the Atho. That is the order dated 18 August 2003.
Yes.
Today is fixed for Atho. After LA case SR number Atho, the petitioner are informed under the office of the Atho and Atho revenue officer and other things reported that all the documents relating to the properties taken from Sushil Kumar Mukherjee under the Estate Acquisition Act could not be found. My lord, that we filed one letter memo number Atho praying for the 2 weeks time to find out the very old records. I sent letter to Sri Krishnananda Mukherjee, state advocate, to record to pray for time of the Dhatu. After that, I.A. Khan, Revenue Officer, Nato Asansol filed Hajira as usual on Soibalato. Now, my lord, appeared before the LA collector is only one. There is one done. Ultimately, he filed Hajira not during the hearing in the office of the taking author. I was very much surprised to know this Mukherjee, who was authorized by all the rest of the petitioner to appear before me with requisition police for their safety and security. Subsequently, he reported otherwise due to peaceful hearing in my office. My lord, that is next paragraph. Here the writ petition is treated as petition for this hearing. Now coming to the examination of the actual case, my lord, the Sushil Kumar Mukherjee, now deceased, got a mining lease, my lord, as vested land, vested under Estate Acquisition Act 1953 for 99 years on Atu. My lord, this point is very, my lord, if your lordship will, that is the now lease vested to the state, my lord, that is Sushil Kumar Mukherjee, my lord, that is Sushil Kumar Mukherjee, now deceased, got a mining lease of vested land, vested under Estate Acquisition Act 1953, my lord, for 999 years on 1/12/1899. The said land was working in 1955, but subsequently stopped in 1956. So after the absolute of the mining of North Musalia Colliery in and around Asansol Mouja, that is, they could have recorded and surface right in their own name. The compensation for the royalty land is already received by them by paragraph number 8 of the petition, and now they are claiming the compensation of 83.45 acres of land prepared at all. My lord, there is two part, my lord. Some amount of compensation already paid to them, my lord.
That is the other three cases. In the earlier three cases, no dispute.
My lord, that is here is, but here, my lord, that is the how the case was formed, my lord. Establish the case, my lord. For that reason, my lord, he was that paragraph is very important, my lord. That paragraph here they are treated that a second paragraph, my lord. Actually, the underground, that is the if land is, my lord, West Bengal Estate Acquisition Act, my lord, was vested to the state, my lord. He has not any right to come before your lordship.
Where is that document?
My lord, I am coming from only for that is, my lord, I am start from his petition. Otherwise, I can't want to take time from your lordship. Actually, the undersigned right of law always vested with the government. So even colliery work is stopped in 1956. How they can claim the compensation of underground right? Still, the revenue officer submitted that one note of advisory committee was sent to the Department of AL and LA for rectification under section 29 of the West Bengal Act 1953. To find out the said notification, he prayed for time and he argued that a recommendation regarding mining lease was sent to the government by the advisory committee constituted under TO number Ato, but no subsequent record is available after passing the time of nearly 40 years. The petitioner also failed to submit any confirmatory proof. Hence, the claim of the petitioner falls. Regarding claim of their house situated, regarding claim of the house that is also situated on the plot number 2542 of the Asansol Mouja, he could not show the original Rayoti Khotian to, on the contrary, on the plot number Ato is found in appendix in the of the petition of property of North Colliery, my lord. My lord, that is, he claimed that 2542 is, my lord, Rayoti land, my lord, but he can't produce that any documents.
Our record of rights, it's there.
No, my lord, RS record, that is the LR record, there is nothing.
So the acquisition was before LR.
Acquisition, my lord, after I am coming, my lord, acquisition. Now, my lord, I am acquisition part, my lord, first acquisition part, he took the money. Now, second acquisition part, my lord, I am coming for that, my lord. Regarding claim of the petitioner about the compensation of plot number flyover land, did not submitted any proof of royalty land. My lord, he can show your lordship proof. Up till now, my lord, he never produced anything that he is the owner of that land. He can produce of that land. My lord, that is the intention of that, my lord. The revenue officer SDLRO submitted that the said flyover is situated on the plot number 24 Ato to 25 Ato and Ato, and as also demanded that the petitioner should submit the Xerox copies of the Khotian also present the original enlist the LA collector, but the petitioner would not submit the above document on 4/8/2003. Hence, the claim of this petition, my lord. In this case, several officers like the ECL, but due to the shortage of time, it was not possible for very old and the case still retired to pass a reason order, which may be look meaningful and reason. So, Soibal Kumar Mukherjee will hold the power of attorney of the author, take note of their self and other things. This order will send to him within 2 weeks from one copy, which will that the SDLR of BL Asansol, mining officer Asansol is the concerned officer of the ECL and sub of the district compensation officer to be sent. The copy could not be sent to the executive engineer PWT respondent. That is the first order, man. Now, my lord, page 16 at paragraph 14. Against that, my lord, he again filed one writ, my lord, in that is paragraph 14, my lord, page writ. And in that writ, my lord, that is on 15 December, that is paragraph 15, my lord, writ petition bearing number Ato came up for hearing before his lordship, Justice Talukdar, my lord, and Justice Talukdar, my lord, passed the order. That is at page, my lord, starts at 2006. That is a copy of the order. That is 2006, my lord.
Not 1000, Mr. Dev.
2009. 2006 too. 206, my lord. Yes, my lord. My lord, now I am coming Justice Talukdar's order. Grievance of the petitioner was ventilated to the learned counsel on that relates to the alleged illegality on the part of the respondent authority passing the order on 18th August. The age of the petitioner appears that the special LAO collector Barwan, in compliance with the court's earlier direction, WP number Ato and Ato, for consideration, passed the said. Heard the learned counsel of the petitioner who submits that it was not right the part of the authority concerned to hold that the writ petitioner could not produce proper document in support of their claim for compensation. Inviting attention of the court to the said order, it is submitted that the petitioner are well equipped with copies of the RS record. My lord, mark is RS record. Up to RS record, my lord, there is no any problem.
Yes.
After that, my lord, there is a problem. Here, in support of their claim, the petitioner, my lord, that is it is submitted that the petitioner are well equipped with copies of RS records in support of their claim. That the petitioner are the owners of plot number Ato and Ato, 4 plots, my lord, that is. The authority concerned seems to have not taken into consideration the fact that the flyover in question admittedly is situated on the aforesaid plot, which was recorded in the name of the predecessor of the writ petitioner. It is further submitted that others standing on the same footing have already been given compensation to them. That is their case, man. That is 2007, 207. Mr. Banerjee, as learned counsel for the respondent authority, submits that such special LAO collector may not be the appropriate authority for dealing with the same. I do not think that such an issue can be raised at this belated stage, and particularly when the said authority did not choose to raise such point. And in view of the clear direction of this court, it is as Mr. Banerjee further submit, it is necessary to ascertain as to how such acquisition of land was made. After taking into consideration the relevant facts and materials and submission made on behalf of the writ petitioner, I find, my lord, that is my learned friend showed your lordship. What is the language, my lord? I find no reason as to why the present dispute has to be kept alive for such a long time. That is a dispute, not, my lord, his case. If for the purpose of construction of the flyover, the same lands have been acquired, if, my lord, first starts line, if for the purpose of construction of the flyover, the same lands have been acquired, and if the petitioner establish their claims, that is a very vital question of, my lord, Mr. Justice Talukdar. If claims they were the owner, petitioner establish their claims, then they are the owners of the said land. It was thus acquired for the public purpose. They are required to be paid compensation. My lord, there is if this is not a, my lord, affirmative, but that is questioning. But there is a dispute, and that dispute, this is not, my lord, in favor of the petitioner. He must establish his case. It is automatically not go. From arrest record, how the land is going, my lord, that was his, he must establish that one. In case the authority could not do so, in lieu of non-availability of non-production of relevant record of right, the same can be taken into immediately, since the present writ application has copies of the said arrest record annex. That is arrest record I may not want to go into. Thus, the present writ application being WP number 8199 of ATO is disposed of with the liberty to the writ petitioners to submit a fresh representation before the authority and the special LAO collector. If such representation is made within the period of 4 weeks from date, then such authority must consider the same in its proper perspective, not at the petitioner's whims. And না না তোমাকে গালাগালি দিতে পারি the prior perspective, and of course in the light of the observation is made hereunder, take appropriate action and appropriate. My lord, your lordship should consider in the light of the observation. Light of observation is, my lord, if. Yes. And take appropriate action and appropriate order. It is for the writ petitioner to establish, my lord, again, Honorable Justice, my lord, again directed, establish their claim with relevant document as indicated earlier. Yes. The entire process of consideration must be completed within 8 weeks from the date of ATO. That is the order, my lord. Now, my lord, again, that was rejected. That is the paragraph 16, my lord. That is paragraph 17, my lord. The then special land acquisition officer, LA collector, only bar 1, perform respondent to appear before him, and after that, my lord, that is paragraph 18. The hearing, though the performer respondent hearing was considered attorney to the petition. That by the order number, paragraph 19, my lord. That is the said special land acquisition officer, part 1, rejected the representation being annexure P of the ATO. That is page. পর্যন্ত হয়েছে, বুঝতে পারলে? এত পর্যন্ত পড়া হয়েছিল, আর মার্কিং নেই। My lord, up till now, my lord, after that, my lord, your lordship will take the matter in another date. As because, my lord, up to that, my lord, I have the noting. After that, no noting is.
Two very simple things.
Yes,
Till
my lord.
RS, two very simple things. Till RS, there is no dispute.
No, RS, there is no dispute.
Title also no dispute. Petition, you have admitted that the petitioner's predecessors were owners.
That is up to RS.
That is admitted, yes.
That is admitted.
RS record is possessed.
After that, my lord, there is a dispute.
Once title is admitted, you
No,
cannot
no, no,
deny
no,
title.
my lord, title gone.
How is
I must come with that. After that, my lord, up till now, my lord, I come with that. After that, my lord, I must
clarify one small issue. You have admitted that there has been an acquisition proceeding under the 48 Act.
my lord, acquisition proceeding otherwise in other part. And my learned friend said the acquisition proceeding for the cause of the national highways. My lord, that is not my lord the problem.
Woodland বলেছো,
না 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 শুটল্যান্ড বলেছি তুমি জানো না my lord, for that reason, my lord, I must
including the suit land.
yes, my lord, including the suit land, that must be my lord. If there is no suit land, my lord, that is the land was vested to the state, my lord. In spite of that, my lord, we can issue acquisition.
Invested land.
Yes, my lord. In past, my lord, that was not noted in the for that reason, my lord. It was, and in my affidavit in my report, my lord, I have stated how. So, my lord, I must come and then, my lord,
And let
complete
Mr.
the
Dey come
same.
back.
My lord, as because, my lord,
I'm putting it to myself. If
না
government
না আর
land
বলো
is
না
acquired,
এই তুমি
who will pass
এই তুমি
award
এখন
in
বলবে না।
whose name?
Mr. Pan, please do not put anything to yourself at the moment. Let
My lord,
Mr. Dey come back.
only thing, my lord, subject to your lordship correction, only just have a look at the section 4 once of the West Bengal Land Reforms Act. It specifies that what is my right, title, and interest. I am the owner as well as I am entitled heritable and transferable right.
Yes. Absolute right, yes. This is settled law.
Yes.
Yes.
My lord, kindly take it up next week, my lord.
Before vacation, it will not be possible.
Then
It will be a lengthy matter.
My lord, lengthy matter, my lord, I must take minimum 1 hour at least. As because, my lord, I must
Mr.
show
Dey
everything.
intimidating the court.
As because, my lord, I take the intimidating point, my lord. I must come from everything.
Availability merits everything, Mr. Dey.
Yes, my
It
lord.
has to be
Now,
dealt with.
now, my lord, merits.
My lord, may I pray one indulgence before your lordship? Kindly make it hard in part. Kindly, because your lordship,
Baba,
kindly, my
yes,
lord,
থাকবে।
kindly, this is my humble peer.
And in all the matters, I'm being requested to make it parter, so I'm not making it in any of the matters. Any matter where I hear for 15 minutes, I'm being requested. That's not possible. Even if determination changes, I cannot carry my entire determination to the next determination. That's not possible.
Very good. I will try.
I don't think there will be a change.
My lord.
We are closing down next
Yes,
week.
yes. My lord. So, my lord, kindly let it at the, sorry.
Yes.
Let it at the top, my lord. Kindly make
Yes,
it.
let me see. Yes.
My submission to the work of the National Highway Authority is to construct road, not the flyover. That is my humble submission.
I'll record your submission when your
I have
turn
never
comes.
said the National Highway taken my, for the purpose of construction of flyover, this is my case. I have
There
not
is
said.
actually no
Yes.
allegation against the national highways.
Yes. Just to
If you
ascertain
go
the
to
exact.
earlier writ petition
Yes.
order passed by me, you can you get a picture of the
Yes.
matter.
তোমার against কিছু নয় তো।
Heard learned counsel for
তোমাকে
the
তো আমরা
parties.
সাপোর্ট করে দিয়েছি।
Paragraph on prayer of learned counsel for the state respondents. The matter is adjourned. Paragraph, let the matter appear under the same heading on
Let it be immediately after reopening, my lord. Kindly.
yes, let it be 8th January.
8th January, my lord. Develop. No, at the top, my lord. Kindly.
It'll appear. It's appearing in any case.
No, kindly,
It'll
kindly.
appear, it'll appear.
My lord, kindly make.
Wait for a date.
My lord, kindly, just one line, my lord, at the top, my lord. Kindly make it. Otherwise, my lord, kindly make it at the top.
Fairly at the top.
Fairly at the top. Deeply obliged to you.
না না 8 তারিখ তো না না 8 তারিখ ও 8 তারিখ
Oh, my lord, 8th is the, my lord, I understand monthly list will open. Make it on 9th, my lord. Make it on 9th.
9th, right.
9th.
Yes, it will be a monthly.
9th.
Thank you. Yes.
9th.
Next.
Obliged to your lordship.
Item number 11.
I for the petitioner.
On the last occasion, Your Lordship, I have prayed for time to file exception,
Yes.
but unfortunately I couldn't prepare it because of some difficulties. Now, as per the report, the state has given a report, Your Lordship. There are two things clear from the report. One, they have paid in the year 2016. Now they are saying that they have offered me the money in 2013. The award is in 2013, but I have not accepted that award. So there is no proof for that. And the second is only I'll ask Your Lordship to come one page of the report.
Why don't you come back with the exception? I'll deal with it then.
My lord, that will
Since
be
you have some objections to
Your Lordship, only the issue is that 3G5 and 3G7 is clear to Your Lordship. They have given a report, Your Lordship.
Yes.
Now, kindly, if Your Lordship sees internal page 12,
Did you
they,
use an exception?
My lord, he will not file exception. Only for that reason he wanted.
Yes, yes.
now, Your Lordship, the issue is that if this, I am asking for 2013 Act to be implemented. If they have paid in 2016, that is definitely they have to pay me in the 2013 Act. Now they are saying that, okay, you have been offered, but you have not. So these things need to be a question of facts which needs to be adjudicated. So my humble submission is arbitration has been done for others. I have not been given an opportunity. Your Lordship has previously passed an order, said let the arbitrator consider this. I'll put my grievance before the arbitrator. If I am being able to satisfy the arbitrator, I'll get 2013 Act, otherwise not.
In fact, the read court cannot deal with this issue. Whether it was offered, not.
Yes, that's what I'm saying. Because my remedy lies under section 3G5.
Yes.
So if I'll make a fresh application before the arbitrator, because after this report, many facts have come to me. Your Lordship, see the 3G1 award which they are saying. Kindly have a look at page. Your Lordship has got the report, Your Lordship. The report is there with Your Lordship, the submitted with the state.
There was an arbitration with regard to others.
Others.
The petitioner was not.
No, there on the last of the arbitration, they give a statement. It is applicable to all the persons in that moja. And kindly see the statement of award. It has got nothing with section 3G7. The ingredients of section 3G7 is not there in the report, Your Lordship. The state has filed the report.
Yes, the report.
Page 12, and my calculation is at page 14.
Page 12 is the 3G1.
Yes, they are saying this is to 3G1. So definitely it should have the 3G7 ingredients. Nothing is there. And page 14 is the calculation which they have provided me the money. That is also nothing is reflected over there.
You are Rabiul Islam.
Yes. Page 14, they say Rabiul Islam, that money has been, this money has been paid in 2016, that is admitted.
This is the 3G1.
They are saying this is with 3G1.
The arbitration had taken place, but according to the report, the writ petitioner did not participate in the arbitration.
There is the notice served upon the writ petitioner.
Exactly. There is no notice with the report.
Only for that reason, my lord.
And there is no refusal as well. They have offered me the money. I have refused. There is nothing on that. That's why I'm saying.
There is a Mimamsa notice, page 19 of the report, which shows that the notice had been served in 2013. Nobody came forward to collect the money. Thereafter, the arbitration has taken place, but even in the arbitration proceeding, the writ petitioner has not participated, but there is no notice, Your Lordship. So in that case, in that event, Your Lordship, if similarly in a previous matter, Your Lordship had directed the petitioner to approach the arbitrator and let the arbitrator decide whether the new act will be applicable or not. Lordship,
yes, let there be an application of the 3G5 by the petitioner.
Lordship.
Yes,
let the arbitrator decide. You admit to have received the 3G1 compensation?
Yes, Your Lordship.
Yes, well.
That is admitted.
It is contended on behalf of the petitioner that award under section 3G1 of the West Bengal of the National Highways Act 1956 has been received by the petitioner
on 7/1/2016.
On 7th January 2016.
Yes, page 3, Your Lordship. Page 3 of the report.
Where is the date? Page 3.
Page 3 says payment details, Your Lordship.
R1.
Yes, R1. The chart is there. On the bottom and the corner, it says the paid on, your lordship, by check.
7 January 2016. Huh? Stop. The petitioner is aggrieved by the quantum of compensation. Aggrieved by the quantum of compensation and seeks to file an application under section 3G5 of the Act before the learned arbitrator for enhancement of the same. Paragraph. It appears from the report in the form of affidavit submitted on behalf of the state respondents that arbitration proceeding was held under section 3G5 of the Act It says Robiul Islam is present. Page 21.
In the top is name of Robiul Islam is there.
So no further 3G5.
Then your lordship will find exception because I have to take, because they have not given any instruction, but I'll give a.
Section 34.
Yes, no, I'll give exception to this. I'll verify from the client and I'll file exception.
Without wasting further time, you can go in for 34. Please find out.
Yes.
He was present in the arbitration.
Yes, ma'am. The name is recorded. Let me see. I have to check with, because.
Sufficient proof.
Yes. If the award is there, then I have to go. And I have to see if they have given me if they have not given me the award copy.
That is page 4, my lord. He declined to take the money. For that is, my lord, he will not get the new Act 13. Opportunity of Act 13. First paragraph, my lord. Paragraph 4.
Lordship, as per the latest judgment of the Supreme Court, the date on which the amount is received by the acquiring body from the requiring body is the date to be taken into consideration. That has taken place before 2014. That means the national. Because in 2013 itself, the Mimamsa notices have been issued to all landowners.
Petitioner has not any case, my lord. By giving exception, he has not any.
Your lordship.
Cannot improve.
Yes, my lord.
Yes, your
That
lordship.
he must file the.
It is recorded that you were present during the arbitration.
Now they are saying that. Now, your lordship, they are saying that in 2013 the Mimamsa notice was issued as offered. Let them produce a record that I have been offered the money, because that they will not.
You have participated in the arbitration proceeding. I don't think that can be considered by the court.
Yes, ma'am.
Your,
my lord, his petition
remedy
is not
under
maintainable. No exception is
Then
necessary.
your lordship kindly direct them to supply me the 3G as per section 31(5) the true copy of this award, because that they have not supplied. Let them show that they have supplied it.
Yes, my lord, he can file an application
can
to
apply
the
for the
authority
certificate copy.
and he will get the
Your
certified
lordship, the
copy.
difficulty is
Your
once
lordship has the order.
because in between to clarify this 3G1 and 3G5, my client went to the office. They are saying as a matter is pending before the honorable court. Only I ask a direction as per, if they have not served, they will submit a copy of the arbitration award.
Has 3G5 been served?
My lord, your lordship can give him that. You will get the.
That direction may be given. I'll get the copy from the concerned authority.
My lord, only to he wanted to save the limitation. My lord,
If they have not served me, then my limitation starts from the day I received that copy.
I'll give you I'll give a direction for service of copy of 3G5. Will you withdraw?
Yes.
And approach the appropriate forum?
Yes.
It is submitted on behalf of the petitioner. It is submitted on behalf of the petitioner that copy of the arbitral award was not served upon him by the authority. Stop. There is also no document on record to suggest that copy of the award was served upon the petitioner. Paragraph. In view of the above, who will serve?
The competent authority, your lordship.
Respondent number?
At that point of time, respondent number 4 was the arbitrator, your lordship. Now that has changed.
No, no, দেবে তো
So respondent number 5 can serve your lordship. The additional distribution land acquisition.
ADM.
ADM
In view of the above, the fifth respondent is directed to serve a copy of the arbitral award under section 3G5 of the National Highways Act 1956 upon the petitioner within 1 week.
No, my lord.
Copy of the award only.
My lord, that is all the papers, my lord, now handed over to the নতুন হয়েছে তো divisional
মালদা চলে গেছে।
মালদা চলে যাচ্ছে সেই জন্য my lord
4 weeks.
yes my lord
Within 4 weeks from the date of communication of this order. Paragraph, the petitioner seeks to withdraw the writ petition and take necessary steps before the appropriate forum. Paragraph, in view of the above, the writ petition being WPA such and such is dismissed for non-prosecution. Paragraph, liberty is granted to the petitioner to approach the appropriate forum for redressal of his grievance. There will be a question of limitation.
As per section 31(5) of the Arbitration
Receive a
Conciliation
receipt of
Act,
copy.
after receive, they have to be certified after receiving only the limitations.
There shall have been notice to cause urgency to fellowship. Next.
Item number
12 and 13, my lord, Mr. Owen Banerjee is appearing for the state. He has not come to court, my lord, today.
12 and 13.
I am praying adjournment for this day.
You're a
My lord, adjournment on personal ground, my lord, I cannot oppose. But my lord, kindly sees the number of, my lord, report was, my lord, directed to be filed, my lord. After that, my lord,
The
that is,
report is also not ready.
I don't have any instruction, my lord. He has not come.
Report is submitted.
after that, my lord, there was a fresh, my lord, order of your lordship, my lord, where inspection was to be held, my lord, afresh, because, my lord, that report, my lord, missed some components, my lord.
Right, right.
On the
Please
Ashwini,
the report on the next date.
Yes, my lord, I shall.
Care of the respondents, the matter is adjourned. Paragraph, let the owner now, Devin. Paragraph, let the matter appear under the same heading on 22nd January. 22nd January. একটু শুনুন ভালো করে। Next. 22
তারপরে আবার ফ্রেশ ইন্সপেকশন হলো না?
Please serve an advance copy. Yes, ma'am.
item number 14.
At 14, my lord, there was a direction to file a report in the form of an affidavit.
এখানে নেই কত তারিখে হয়েছে আগেরটা অর্ডারটা বলো না ঠিক আছে নোটিংই নেই
Have you used an exception?
No, a report has yet to be filed, my lord. There was a direction to file report by the statement.
my lord I have not completed my ad because my lord on the previous
Report in
occasion
the
that
form of affidavit submitted is taken on record. This is
Well,
the
most-
report.
Most probably, my lord, different file.
16735.
No, no, 3159 of
3159
2019.
কি দিচ্ছেন?
3159 14টা উঠে দিচ্ছিস 13টা উঠে দিচ্ছিস দেখ
পরেরটা
এইটা হবে
14.
হ্যাঁ এখনই নোট করে দিচ্ছি
এটা পরেরটাই আছে, রাখুন হাতে।
এই তো 3159 দাও অ্যালুমিনিয়াম আছে নাকি দেখ
It's compliance of an earlier order of this court.
But I am, my lord, perusing my lord's order dated, my lord, 16th November 2023. Yes, compliance of the earlier order of this.
Yesterday. Where is the earlier order?
But,
In WP number 2064.
direct purchase some post
that is at page, my lord, 50.
with
উইথ আছে আপনার নিয়ে থাকো
On behalf of the state, my lord, initiation of direct purchase policy, my lord, they.
Yes, and that has been observed also in
My
the,
lord.
have you seen this order, Mr. Dev, page
Yes, my lord.
50?
Now I can see, my lord. That order we passed, my lord, within 3 or 4 months. that is-
For compliance of this order?
My lord, for direct purchase. মানে demarcation এর তো। না, 19 না। হ্যাঁ, এটা করে দিয়েছি। 15, 14 এটা করেছি।
But already there is an order, my lord, passed by my lord, regarding submission of report, my lord. But
My lord,
let
there
the
is no
report be
necessity of
submitted, my lord.
The state doesn't intend to submit a report.
But there is already an order, my lord.
The state seeks to submit, not a direction. Now the, if
Now,
the
my
state
lord,
comes up and says the state
Now,
doesn't.
I have seen the, my lord, previous order. Previous order is perfectly right, my lord.
So
that
let this order be
direct purchase-
complied with, because your land
direct
has been
purchase.
expropriated
Yeah, it is
without
complete.
compensation.
My lord, let the, my lord, the, so far as the direct purchase policy that be implemented, my lord, at the earliest, my lord.
Yes, within a, let this order be complied with a, I'll just record this part of the order.
My lord.
Yes, my lord. That is first part of the order, my lord.
Second paragraph, first page.
Yes, my lord.
এটা করে দিয়েছি ডাইরেক্ট পারচেজটা করে দিয়েছি
তাহলে
ডাইরেক্ট পারচেজ করে দিয়েছি
First page also, my lord,
কত টাকা
paragraph,
সে নিয়েছে
that is direct
আর
purchase
বাকি
policy
ব্যালেন্স
is
এই
correct.
যেটা আছে
That will be,
All that is required to be done from that
Yes, my
part,
lord.
only that paragraph I'll record. Let that be complied with.
yes, my lord.
Yes?
No, এটা ভুল
My lord, our contention is that, my lord, demarcation of the land is also required, my lord.
In order to implement this order,
That's
they have to demarcate the portion, isn't
my
it?
lord, my lord, my lord. That
That should be
my
consequential.
lord, that is the thing, my lord, we want, my lord. After demarcation, what is the land they are taking, my lord? Because something, my lord, requisition is done, my lord, for certain extent of land, my lord. Ultimately, they purchase the less amount of land. That is required, my lord, for
So,
clarification.
Mr. The compliance of this order upon demarcation, because the area you
My lord.
utilize.
Yes,
Yes.
ma'am.
Let me record an order
My
to that
lord.
effect. Report will not develop the case
Yes,
anymore.
my lord.
রিপোর্ট ছাড়া হবে না
How will the report help?
But unless my lord, requisition is total requisition and total they want to take, my lord, again they
They
have
have taken
difficult,
already, that is your submission.
my lord. But their case is that our so far as our cases goes, my lord, to some part they have already, my lord, taken and given the money. So far as the other part, my lord, they are not releasing, and neither they are releasing, neither we can utilize. Right?
রিয়ালিটি আছে আমরা ডিমার্কেশন চলছে তো কতটা এরিয়া রিকুইজিশন করেছে সেটাই তো জানি না
That is paragraph, second paragraph, my lord. All that is required to be done.
Yes,
For the
yes.
response, determine the calculation of the compensation direct purchase amount for the land admittedly utilized by the irrigation department. And of the state in terms of the order of the special land acquisition officer. That is, my lord, the calculation.
My
this
lord,
is the
prayer A,
demarcation-
my lord will kindly consider prayer A, my lord. Portion of the land which was utilized by the authority and which is the subject matter of requisition involved in such and such LA case.
That will be considered, that will be done, my lord, within certain time.
And prayer C, my lord, we have prayed for rental compensation also.
So it is not really implementation of the earlier order.
My lord, not to that extent, my lord.
Let the report come in that case. They have additional prayers also in this.
But in the report, my lord, it is not possible. How much portion utilized by the irrigation department? That is, my lord, there is a bifurcation of order.
স্পেশাল অর্ডার আছে
Utilization by the irrigation department.
এখানে দেখা
So shall there be an order for demarcation then?
Yes, my lord.
A joint field inquiry?
Joint field inquiry, my lord, done by the irrigation department. After that, my lord, The order passed by the order আছে স্পেশাল অর্ডারটা আছে ইউটিলাইজ কতটা করেছে এখানে আছে স্পেশাল
Page 48, page 48.
The inquiry will be done by, let there be a joint inquiry, otherwise we cannot come to a solution, isn't it? It has to be done by the irrigation and waterways.
My lord, your lordship.
Irrigation, waterways, and my lord, the acquiring body and the requiring body both, my lord, must be present.
Page
Page 48.
40,
48. 48.
48.
তুমি কি বলতে চাইছো? As per the officer is found the
Yes.
My lord, findings. So the claim of the structure value does not arise as per utility report submitted by the department is the following. That is the, my lord, no demarcation is necessary. As there is a, as per office record, it is found that the suit land was not acquired. The petitioner agreed to accept the compensation value of the land utilized, which is a direct policy of the government of West Bengal and so the petitioner is entitled to get compensation of the utilized land of the suit plot of the establishment of his right. So my lord, your lordship
And
can
this
pass the
order,
next
this
slide
has
order.
been referred to in the earlier order of this court.
My lord, utilized land and my lord, requisition land, my lord, there is difference. That is the thing we want, my lord. Because the different land, my lord, they have to release that land. Or my lord, they have to pay compensation for that also.
These are the areas, page 48.
48.
These are the areas that are admittedly utilized.
Yes, ma'am. Utilized by the.
Is
that
there
has-
any further area which has been utilized?
Balance stated.
Not the papers are not with us, my lord. Only, my lord, physically we do not get return of this.
This is the entire plot. What
আবার
is
তুমি তো এইটা
what does your
দিয়েছো
repetition
এটার
say?
বাইরে তার কি যাবে
My
না
lord. My lord, in the writ petition, my lord, we have said, my lord, the acquisition part, the requisition part. Page. My lord, out of areas, my lord, we have given the 0.691 acres has been taken over, my lord. But out of the total requisition area, my lord, that is not clear to us. That is the report we seek to get, my lord.
Is that your case in the writ petition? Because paragraph 2 refers to the plots.
My lord.
I think these plots, they say that they have acquired, and you have not stated the
Those lands were not
quantum.
acquired.
You have
As
not
per
stated the
record
quantum of
found
land.
that the suit land was not acquired.
Your writ petition is silent with regard to how much of land. You claim to be the owners of the entire plots.
My lord.
Page 48 gives the areas of plots utilized without acquisition. They are agreeable to purchase these plots directly.
ওদের জানতে হবে কতটা রিকুইজিশন হয়েছে রিকুইজিশন নোটিশ থেকে জানা
And
যায়।
where have you made out a case that the
Well,
entire plot has some acquired, some utilized?
My lord, my instruction is, my lord, we did not get the requisition notice properly, my lord. My lord, that is the only thing we require.
In respect of these plots, the
My lord.
state admits that they were not acquired, they have been utilized.
My lord.
And they want to purchase it directly.
My lord.
You say that there are some other portions also
My lord.
besides these.
My lord.
Where is your case in the writ petition? Because quantum has not been stated in your writ petition at all.
My lord, we have annexed the record of rights, my lord.
Averment in the writ petition, prayer in the writ petition. You cannot go beyond that.
সে তো government করোই নি তো তোমাদের
The quantum is not in the writ petition at all. You have not stated the quantum of land.
But we will produce a supplementary affidavit. But unless that is produced, the entire picture will not be
You
clear.
cannot bring out a new case in your supplementary affidavit.
No, but we'll.
There is your
my lord,
case that some portion, you have said acquisition proceeding was not intimated to the petitioners.
my lord,
That is your case in the writ petition.
my lord.
The state agrees to that.
My lord, that is the reason, my lord, extent of land that was actually requisition that we cannot calculate, my lord.
There was no question of requisition at all. The state says there was no acquisition.
No, my lord. Initially, my lord, under the Act 2, my lord, the proceedings were initiated. Thereafter, my lord, by the lapse and they have now stated that they will purchase directly.
If that, my lord, lapse, if for the sake of argument, my lord, then that part goes.
No, my lord.
Only, my lord, only thing, my lord, that the, how much utilized. That is the utilization is there, my lord, page 48. And they arrived at direct purchase policy of the convention. The petitioner agreed to accept. My lord, at that time, my lord agreed to accept the same compensation.
Yes.
And filed
No,
a
no.
new case, my lord.
So far as compensation, my lord, that is another part, my lord. The other part is, my lord, the extent of land. My lord will kindly, my lord,
Extent of land is
the-
recorded in page 48.
page, what they have taken.
Yes.
What they have taken, my lord.
You have agreed on to this.
No, so far as, my lord, the agreement, so far as the other part, my lord, if they don't take the
They have not taken any other part. Where is it stated that they have, there is
no,
some
my
other
lord,
part also?
since we did not get the notice, my lord, we are not sure, my lord, to what
lord,
extent, my lord, requisition was done.
Petitioner submitted that
Unless, my lord, they give clearance to give clearance to such unused land, my lord, we cannot use it, my lord.
Where is the averment in the writ petition? You can withdraw and file a
My lord,
fresh.
there is some deficiency, my lord, I admit, my lord. My lord,
Withdraw and file a fresh writ petition.
Supplementary file.
Supplementary.
Because that point is not taken at all in
Yes,
the
my
writ.
lord.
My lord, we will,
Only for
my lord,
that
withdraw at liberty to file a.
That story clear,
My
isn't
lord,
it?
with liberty to file a.
The petitioners seek to withdraw the writ petition on account of certain defects detected therein and seeks further liberty to file a fresh writ petition on the same cause of action. Paragraph. In view of the above, the writ petition being WP such and such is dismissed for non-prosecution. Paragraph, liberty is granted to the petitioner to file a fresh writ petition on the same cause of action. Paragraph, there shall however be no redress to costs as in certified website copy.
Great.
That point has to be clarified.
Item number 15.
15. For the petitioner.
Yes.
Yes. Taking an exception,
Yes,
sir.
yes, sir.
Mr. Day is appearing. What is the issue about?
Your Lordship, this is an issue that the land was, I have purchased this property in 2008. And there being a milk factory is being run in that particular property. In 2018, there was no acquisition notice submitted to me. In 2018, a notice came to me that you are an illegal occupant over there. So the first time I came to know that this land has been acquired. I made a representation before the concerned authority. They gave me hearing. And after giving me hearing, they said this land was acquired in 2010, which the intimation, they cannot show me any notice to me before 2018. Now, Your Lordship, they have given an exception. The exception is, first thing is the 3G1 that they have supplied in this. Kindly have a look at if it's 3G1 or not, because it has to have the 3G7 component. And I'm running a factory, they're not disputing that. Their person went over there, they have calculated, they have remeasured, everything has been done. Kindly see the report, Your Lordship, filed by the state.
I think the National Highways is not in a position to make their submission to you. Come back after vacation.
That's I've already.
After vacation. You are not ready. On prayer of the National Highways Authority of India, exception submitted by the petitioner to the report in the form of affidavit submitted on behalf of the state of the respondents is taken on record. Paragraph on prayer of the National Highways Authority of India. The matter is adjourned. Paragraph, let the matter appear under the same heading on 22nd January. Next.
Item number 16.
My lord, item number 16, my lord, I'm led by Mr. Das, Jayant Kumar Das, my lord. My lord, kindly gone through your lordship's order and
The
December
respondent,
7. My learned friend is there.
here for
I
the
was to file an affidavit on behalf of the respondent number 8.
copy served.
My lord, it was, my lord, affirmed only yesterday. My
My
lord.
lord, let me go through and come back.
His learned senior told me they will hand over the copy today. My lord, I had to show compliance of your lordship's order dated 4th of September.
Yes.
In. I had to copy that.
আরে হ্যাঁ রে বাবু
আমার কপিটা না আর একটা পার্টি আছে তো
বেসিক বলে আছে
জানি বলেছে আমাকে বলে গেছে বলেছে আমি থাকবো না
Demarcation has been made.
Mother, it is scheduled to be held on 15th, Mother. There is tomorrow, Mother. We have given notice on 8th of December. Earlier we went, Mother. That details we have provided in the affidavit. Your lordships will find, Mother, steps taken in compliance of your lordship's earlier directions from paragraphs 3, 4, 5, and 6. At that time, my lord, it was being immediately after the monsoon. There was a bit of water logging, my lord. And my lord, there's also outgrowth. But I had handed over 2 photographs on the last occasion to show.
My lord, in that event, my lord, let me gone through and come back.
Yes.
My lord, let me have a gone through the report and come back.
But in any event, my lord, the demarcation is scheduled tomorrow. So we can come back, my lord, after the ensuing vacation also.
Yes,
subject to your lordship's list permitting.
Where is the block land and land reforms officer?
My lord,
Where is he?
my lord, he is not present today.
Why?
Uh,
His appearance was not dispensed with.
my lord,
Not today. Come back tomorrow. এটা ফেরত দিয়ে দিন।
may we come back on?
Limit to non-compliance, defiance.
But we have missed that part of the order, my lord. It's our mistake, my lord.
Now he'll be here on every date. Not today.
But maybe on Monday, my lord. Tomorrow the demarcation is scheduled, my lord. Or we can postpone the demarcation, my lord, subject to your lordship's convenience, my lord.
The block land and land reforms officer is not present in court despite direction of this court. Paragraph, let the matter appear under the same heading on nineteenth December.
Grateful.
Next.
Thank you. Grateful.
Item number 17.
না আমার কাছে
And
ছিল তো। আমি পাইনি
Put on prayer of the state respondents, the matter is urgent. Not present এর পরে একটা line করুন, the on prayer of the state respondents, the matter is urgent. বলে 19th December. Yes, next matter.
my lord, I am for the petition, my lord.
Report, Mr. Bhattacharya.
But we have received report, my lord.
দাদা কপি দিও একটা
Affidavit.
আমার কাছে নেই গো।
But initially, your lordship directed me to file report in the form of affidavit. We have prepared that, but that was not more satisfactory. That is, your lordship on the last occasion asked me to take some instruction, my lord.
And there is again a direction for a report in the form of an affidavit.
I have received report, but not in the form of affidavit, my lord. Last direction, my lord, is on, my lord.
I'll make it not today. Can you come back tomorrow with the affidavit?
Tomorrow, day after tomorrow, then, my lord.
Saturday.
Because the 3G5 calculation has not been made. That was your
My lord, twofold grievance. One is, my lord, that, my lord, the learned arbitrator has, my lord, passed an award whereby, my lord, he has, my lord, made the enhancement of rates, my lord, for different classes of land. My claim, my lord, was twofold. One was, my lord, after it was, my lord, enhanced, no, my lord, a calculation with regard to my compensation that was made. And secondly, my lord, my award, my lord, whereas the land is a recorded BT land, I am being, my lord, given the award, my lord, in respect of an agricultural land. Therefore, my lord,
By the arbitrator.
not by the arbitrator, because, my lord, the arbitrator cannot take up, did not take up individual cases. He, my lord, passed a general order for the entire Mouja, whereby, my lord, only the rates were increased.
So you're not aggrieved by the arbitrator's order?
No, because the arbitrator has, my lord, made already already, my lord, enhanced the my lord rate, and, my lord, I am satisfied with that
With
rate.
regard to categories of land.
Categories of land, and, my lord, the calculation per, my lord, after the my lord, the award was passed, the compliance part, because, my lord, it is specifically, my lord, the award ends with, let this order be communicated to the competent authority NHI and additional district magistrate to all concerned for information and compliance. That part is not done.
My instruction, if any award is passed, they have to apply for certificate copy. They have not applied for certificate copy. When they have participated in the arbitration proceedings.
Yes, they are not aggrieved by they are not challenging the award.
But
they are challenging the consequence, the result of the award.
My lord, the report of the NHI says go to section 34. Like general, my lord, like all other matters.
The last year they have submitted that the copy of the award has not been supplied to them, my lord. But my instruction is they have to apply for certificate copy that they have not applied.
If that be so, my lord, the arbitration act specifically states is the duty on part of the arbitrator to supply
It
a
has
copy.
been uploaded in the server, my lord. But my lord, the specific individual, if you want to get the certificate copy, you have to apply.
Please come to the provision itself. It says service of copy of the award to each of the awardees.
My lord, be that as it may, my lord, it was specifically, my lord, directed on the additional district magistrate for my lord, compliance.
National Highways Act.
That would, my lord, be in the arbitration act, my lord, subject to correction, my lord.
ওখানে নেই।
দেখো না Jackson consultation.
The prayer is that for reassessment of compensation or
Yes.
similar
In terms
of the arbitral award.
In terms of
that has been done, my lord. Assessment enhanced the compensation amount. After arbitration enhancement has been done.
What? Please come to the arbitral award in that case.
My lord, it starts at, my lord, page number 18, my lord, it starts. My lord, I am on page number 22. My lord, kindly take some, my lord, page number 18 first, my lord. Whereas it appears 184 awardees have submitted petitions. So, my lord, by a common order, 184 arbitral applications are being disposed of.
That is true.
That in itself, my lord, in subsequent orders of this honorable court, my lord, were considered to be, my lord, not
But
proper.
you appeared in the matter.
I appeared, my lord. I am not complaining regarding that, my lord. Page 22, my lord, kindly comes. From the bottom part, my lord, hence it is ordered. After that, my lord.
These are the rates given by the arbitrator.
Yes, my lord.
For 184 awardees.
This has to be decided by the authority on the basis of this award.
By the competent authority, my lord.
Yes. The arbitrator has made a general order, a common order.
Yes.
For all 184.
141, my lord. I beg to be corrected. 141 were disposed, the remaining were not disposed by this order, my lord. My lord, kindly comes to the last line, my lord. Let this order.
Yes. See the last line, it should be communicated for information and compliance.
Yes,
Where
ma'am.
is the compliance?
Whether my lord, in terms of arbitral enhancement has done or not.
Yes.
That is not, my lord, there in the report.
There is nothing wrong with the award. Right? Award is all right. The award has to be complied with.
Yes, ma'am.
Calculation in respect of individual awardees need to be made.
Yes, ma'am. On that point, let me take instruction, my lord.
If that was the instruction that was necessary.
Yes, yes, ma'am.
So
That
please
is-
come
My
back.
lord, kindly indicates in the order, my lord, of your lordship, my lord. Otherwise, my lord, on the last occasion, it fell from your lordship that only this much instruction, my lord, the matter can be disposed of.
Learned counsel for the state respondents seeks extension of time to submit the report in the form of affidavit as sought. Paragraph report in the form of affidavit be submitted on the adjourned date, indicating whether the arbitral award whether the award assessed by the arbitrator in the arbitral award has been complied with regard to the petitioner herein.
By the competent authority, my lord.
By the competent authority. My lord, it was on, the direction was on competent authority and the additional district magistrate LA, Nodia.
Has been complied with in terms of the award. Both the authorities are there.
It has been calculated, the documents, my lord. I shall disclose in the affidavit, it has been complied with.
Has been
Documents with me, yes, my lord. Documents with me, my lord.
Tahle
I shall disclose in the affidavit.
Have a copy of the
No, my lord.
I shall file a report for that point, my lord.
let the matter appear under the same heading on 18th January.
My lord.
Next. Oh, mention matters.
Mention matters.
Yes, your question.
I am 511.
Next লর্ডশিপ বলেছেন নেক্সট ম্যাটার
Mention matters from 12:30 p.m.
Yes. But in this matter, I appear for the petitioner. But similar three other matters were heard by Malad Justice Vibhash Patnaik, and his lordship was pleased to pass an order.
The National Highways wanted to take instructions in this matter.
Yes, on 7th of December, the learned advocate.
Ready with your instructions?
The demarcation has already been done. The ATM area of Murshidabad to file a report to National Highways Authority. Until the report is filed, the National Highways Authority cannot do it.
One report has already been filed before my Lord Justice Patnaik, and after considering the said report, his lordship was pleased to pass an order.
In the same matter?
Yes. In a similar three other matters were disposed of by his lordship. Now, I am praying before your lordship, a similar order be passed on this matter also. Your lordship was kind enough to consider this order and was about to pass an order in the similar terms.
Notice
Yes, madam.
dated June 1st, 2022.
Is here the authority made an allegation that the petitioner has re-encroached the property that was already been handed over to the authority. Now, a dispute has arisen whether they are the actual encroacher or not, because for very many reasons, the lands are not being utilized for the purpose it is being acquired. Now, a dispute has arisen. Therefore, his lordship was pleased to grant an opportunity to the petitioner before his lordship to make any presentation before the authority concerned within a certain period of time, and the authority is to consider that same. That is the very inopportune prayer I have made before his lordship, and an order to that extent has been passed. Similar order may be passed in this matter also. Nobody will be prejudiced.
Yes.
My lord, in this matter, my lord, on 26 subsection 2 notice has been issued on June 2022. After that, my lord, my learned friend lordship appeared in the hearing, my lord. And on the basis of this lordship, one representation has been submitted. And thereafter, my lord, the National Highways Authority sought for certain documents from the ADM LA Murshidabad lordship. And after that lordship, the demarcation has already been held. So lordship, some documents are awaiting from the ADM LA Murshidabad, so that lordship, we can pass the recent order on the basis of this notice, my lord.
Presentation is already pending before you.
No, lordship, that has been pending, lordship, on 20th June 2022. My lord, I am not Lordship, that representation has not been annexed in this writ petition, my lord. So that that is my instructions, my lord.
You have already filed a representation.
Not from my side, my lord. The previous matter was dealt with by the authority, but there was no representation in that case.
Yes, but here learned counsel says that there is a representation.
Might be there is some misunderstanding. So far, my instruction goes, there hadn't been any instruction, representation. Your lordship, your
There is already a representation.
no.
My lord, my submission is, lord, he has already participated in the hearing, my lord. At this moment, my lord, we are unable.
Further representation is necessary.
So if that is so,
it is required. Might be there is some
Let
misunderstanding.
the authority come back with a report in the form of an
my lord, I will.
But let it be then in the new year, because for the time being, I shall not be.
Because let her come back with a report. The learned counsel for the National Highways Authority of India submits that pursuant to the notice issued upon the petitioner on 1st June 2022 under section 26 within bracket 2 of the Control of National Highways within bracket Land and Traffic bracket closed Act, 2002, the petitioner submitted a representation before the authority and participated in the hearing conducted by the authority. Learned counsel seeks to submit a report in the form of affidavit in this regard. Paragraph, let the matter appear under the same heading on 25th January. My lord.
But may I take back the order?
My lord, one indulgence, my lord, kindly recorded, my lord, the joint demarcation has already been held, my lord. If your lordship kindly recorded this.
Has participated, বললাম ওখানে একটা line add করুন, a joint a demarcation of the plot in presence of the petitioner has been held.
My lord, in presence of the petition, my lord, that has not been my instructions, my lord.
Joint demarcation there.
My lord, the ADM, LA and lordship, the National Highways are present, my lord. On the basis of this, my lord. My lord, then my lord.
But I had a hunch that there is some misrepresentation there. The petitioner.
Demarcation has already been held, my lord. That is true.
That is there, but no
That's the
representation.
reason why I have called for a report in the form of an affidavit.
That order was sufficient enough. Your lordship could have passed that order.
Demarcation meant like
My lord, the returnable date is 25th.
25th January.
Grateful.
Next.
Item number 512.
May I please, your lordship? Lordship, this matter has come at my instance, your lordship. The state has been served. Yes, my lord. If it is service, my lord. State has been served, your lordship. And respondent number 1 and 2 all have been served. Only, my lord, respondent number 4 has, my lord, it is yet to receive, my lord, they are yet to receive the writ petition. But my lord, state is there, my lord. My main grievance is against, my lord.
Maybe, but you have
respondent number 2.
Yes.
Lordship. Very innocuous
Thank
prayer.
you for being candid. Please come back after service. Let them
I'll file a
I can
fresh,
get
your lordship. Yes, my lord. This one number 6, 4 and 6, your lordship.
affidavit of service. Since service upon respondent numbers 4 and 6 is not complete, let the matter stand over till 25th January.
25th January. My lord, next week, if possible, your lordship, because
No further days before. We
Next.
just have a week to go.
very well, my lord. Under the same heading, your lordship?
No, motion.
Motion. Grateful, my lord.
Under the heading motion.
Item number 513.
I am for the petitioner, my lord. This is my affidavit of service, my lord. My learned friend is there.
Yes.
My givers is that, my lord, kindly come to, my lord, page 16, my lord. Page 9, my lord, paragraph 16, my lord. The awarded money was, my lord, 9,12,294, but they have not given the same amount, my lord, to the petitioner. So, my lord, petitioner came to them in contempt proceeding. They, my lord, page 9, paragraph 16, my lord. Rightly passed award under the middle, my lord, middle portion.
Where is the document?
Document, my lord, they have yesterday, my lord, they have handed over a report. It kindly come to their page 15, my lord, page 14. আপনি এই রিপোর্টটা দিন।
রিপোর্ট
হ্যাঁ করছে হ্যাঁ জলসি তো ওইটাই দেখছে যে ওইটাই তো পয়েন্ট যে 9 লাখ টাকা ইয়ে করে দেয়নি আমার
that is the only issue.
only issue my lord. Awarded amount, this is the document my lord, they have my lord yesterday handed over my lord, this is the document awarded amount my lord, last line my lord, payment to be made rupees 9,12,294, but my lord, they have not paid.
What is your prayer? First prayer?
Yes my lord. To my lord, because my lord,
Cancel or withdraw the impugned award?
award my lord, because my lord, that was passed, my lord, same was not granted my lord. Same was-
Directing the respondents to cancel or withdraw the impugned award.
award my lord,
This
that
is asking for cancellation of the award, not for the amount.
amount my lord, this is not a award my lord. Subsequently my lord, subsequently award was my lord lesser my lord. Subsequently this money was my lord released in my favor my lord, but they have not given it because my lord, awarded amount is my lord, low my lord.
If the award gets cancelled, how can you receive the money? Your prayer is for cancellation of the award.
My lord, modified to the extent my lord.
How?
My lord, kindly direct them to pay the my lord, the awarded money my lord.
Direct them. My lord, you also were to direct you. And that is.
Then pass an award of compensation to the petitioners. This writ petition is not maintainable at all.
Yes, my lord. Petition is
Contradictory prayers.
My lord, my lord, as per my lord, your lordship already kindly see the last order your lordship was.
The writ petition you say that they have declared an award.
Yes my lord.
In the prayer you say for cancellation of the award. Now you are asking for the money.
My lord,
There are three separate
if
contradictory
my lord,
prayers.
total money which was released in my favor, but they have not awarded it my lord.
Where is the prayer?
My lord, if the award is
If your prayer is for cancellation, you cannot pray for release of any portion of the award.
because my lord, I tell him, my lord, because they have already my lord, made payment my lord, because my lord, as the contempt my lord, contempt he was made payment my lord. Only my lord to direct
Sorry,
them
you are asking for- I do not understand.
my lord, as per their report my lord, your lordship direct them to pay my lord 9,12,200 my lord, that amount my lord, only that amount as per their report my lord. Report was some after filing the writ petition my lord.
Is your case also in the writ petition?
Yes my lord, but
Passed an award
Yes.
of rupees 9 lakhs and odd.
but no 3 lakhs my lord, so my lord, I praying for my lord, but my lord, the
9 lakhs was my lord calculated.
yes
Everyone yes.
sorry
As part at 13 months. But according to the yes, my lord, he will not entitled to get the act 13. So my lord, you according to that my lord, hold that award was calculated and amount was 3 lakhs. That is my lord.
So now you are happy with the 3 lakhs?
yes
Yes, my
You don't require anything else?
kindly come to the page 65 my lord, kindly say in contempt my lord, kindly come to the page 65 in order of contempt my lord,
My lord,
your lordship's order my lord, your lordship's order.
as the order at page 31. What is the your lordship's order?
Yes. ঠিক আছে
Your lordship will see your lordship's order. The state respondent submit that though petition for fund has been then for requiring author, such fund has not been placed by them. After hearing the landed counsel for the parties and
This is
considering the
page?
materials on record, the writ petition is disposed of with a direction.
Page?
Page 31, that is the
writ petition my lord, initial order passed by your lordship my
This is the initial order.
Yes, madam.
After that, page 65.
lord, yes my lord, page 65 my lord,
That is the subsequent order.
contempt.
Well, first your lordship will see this order.
Yes, I've seen that order. Yes.
My lord, I submit to your lordship in my way that after hearing the landed counsel for the parties and considering the materials on record, the writ petition is disposed of with a direction upon the requiring body, respondent number 7, to place the necessary funds. That is a very important. Before the state authority for disbursement of the same within a period of 3 months from the date of communication of the order. The state respondent should disburse the said compensation in favor of the petitioner within a month. That is the, my lord.
Please come to 65. It is a subsequent order, contempt application. It has been clarified in that order.
My lord, contempt application, that is the liberty.
Yes, your lordship was granted liberty.
Right. That is your lordship said, my lord. However, in the event of the petition is agreed by their compensation disbursed by the authority to him, he is liberty to take necessary. My lord, I am not going into that.
No, no, no. This 3 lakh something has been paid and the court has accepted it.
Yes, ma'am.
Due to the recalculation, that part is over.
Yes, ma'am. That is, it is submitted on behalf of the petitioner, though the petitioner was served notice to the effect that compensation was estimated by the petitioner received only an amount of the remaining amount has not been paid to the petitioner till date. Your lordship's order. Learned counsel for the alleged contemnor submit that the estimate sent to the petitioner was only a tentative estimate, which was not vetted by the joint secretary and other things, and assessed compensation. The estimate was recast after vetting, and the finally assessed compensation arrived at amounting to rupees 50 lakhs was disbursed in favor of the. In my considered view, the explanation given by the alleged contemnor with regard to the variation of the initial estimate and the amount of compensation paid to the player being satisfactory, the order under contempt has been.
That's over. That part is over.
That's right.
And what is your fresh application then?
Fresh application is remaining amount, my lord. Your lordship granted liberty to challenge that portion, my lord, because my lord, your lordship already stated, my lord, that they have a release amount is, my lord, release amount, payment to be made, my lord, 9 lakhs. They have
Memo dated 1st April 2022,
yes, my lord.
which you have challenged. Memo dated 1st April 2022.
Yes, ma'am.
This has been challenged.
Yes, ma'am. It is the
From where does this amount come now? 283450?
Yes, ma'am.
Page 45, the impugned memo.
My lord, that is, my lord, if I read this application. As liberty given, my lord, why this application is not maintained? I am coming, my lord. Now, my lord, your lordship come to my report.
No, no, Mr. De, please come to this page 45. It says that the estimate amounting to rupees 2,83,000 and odd.
Right.
yes.
Is prepared for compliance of the order of the High Court.
Yes, ma'am.
Where is the order and what is the compliance?
My lord, in my report, my lord, I have stated everything, my lord, in a very. My lord, if your lordship will come, that is your lordship's order in, my lord, page 31 first, my lord.
Yes.
That is in that order is, my lord, WPA number 5392 of
Yes.
21.
Yes.
Now, my lord, your lordship will come. My evidence in opposition in that starts at page 7.
Of the report?
Yes, ma'am.
Page 7, yes.
Page 7, ma'am.
Yes.
That is 7. After that, my lord, I have stated paragraph 4, my lord, that the instant repetition arises in a case number Ato and Ato, and my lord, in a case number Ato, that purpose of the same project could not be disposed of finally under the Ato. And lastly, my lord, page 9, my lord, that the acquisition under section 3(1) of Act Ato 9 was passed on Ato by the Deputy Secretary Government of West Bengal and Ato, and that possession of the said land was given, man. That an estimate probable case of acquired landowner is Ato was made, and the requiring body was informed to place the fund of rupees 64,72,000 Ato for payment of compensation by memo number Ato, and memo number dated Ato, but no fund was placed from the requiring body. That is the total fund, my lord, total acquisition fund. And your lordship passed that order, my lord, to pay the total amount. That the revised estimate for publication of award was done, and requiring body was also requested to place the stated fund for disposal in compensation in memo number, my lord, your lordship will date, my lord, 1/11/2013 by memo number ato, but the referring body did not pledge the fund. For my lord, with regard to the statement made in paragraph 1, 2, 3 and other. Now, my lord, if your lordship will page that is, my lord, your lordship pass the order to pay the total amount. This is my lord, total amount. And place the fund in 2013 according. Now, my lord, what is my report, my lord? If your lordship will come to the please see in that report. That is the first page, my lord. Last paragraph. The petitioner made representation and also filed WPA number ATO in the High Court and order dated 22/21. The Honorable Court disposed of the said petition internally with the direction of the referring body to place necessary funds before the state authority for disbursement of said compensation in favor of the petition. And my lord, and again on application of contempt application, only that is the facts of the case, my lord. After that, my lord, our report, that is the CPN, my lord, that is the in case number ATO, that is page 3, my lord. Needless to mention here that the pursuant to the order of ATO passed by the petition, WPA number ATO and everything in opposition filed on behalf of the state respondent 5E2F, it has been mentioned that an estimate to a case of fund requisition under Act ATO was made and requiring body informed placed the fund of 64 lakhs and ATO for payment of compensation by memo number ATO dated 30. And subsequently revised estimate was sent to the recurring body for by memo number ATO, and said estimate was for the total acquisition land of 17.40 acres of the particular land case number ATO. Subsequently, my lord, your lordship passed the order to place that fund, that is the old Act fund, that is 64 lakhs. The state respondent submit that no requisition for fund has not been sent to the recurring body. Such fund has not been placed by the respondent number 7 before the state authority. Upon hearing the learned counsel for the parties and considering the materials on record, the petition disposed of with the direction of the recurring body to place necessary fund before the state authority for disbursement of the same within the period of 3 months from that. So, my lord, on that day, my lord, there is been a new Act. Only old Act, your lordship passed the order to place the fund of the old Act. In fact and view of the same, my lord, the special land action officer was sent to the executive engineer. My lord, now my lord, what is the wrong in calculation of the in fact of the my lord, the special land action officer estimate and that is 9 lakh was sent to the executive engineer, Right Bank Irrigation Division, in response to his request made by number ATO that is wrong. What it mentioned here, that the said estimate was not vetted by the department and not final. It was only a tentative estimate, as this office was under a bona fide impression that to comply with the direction of the Honorable Court, also to keep the lifetime limelight as directed to the Honorable Court, tentative fund should be estimated from the recurring body, that is the executive engineer from the subsequently, by memo number ATO, the additional district magistrate put out the above estimate in ATO, which was prepared 9 lakhs. Under the right to that estimate was prepared by the right to fair compensation transfers. Here is an act in respect of WPA number 5392 of ATO related in the case number secretary ATO. In response to the above memo, sending estimate, the Joint Secretary Department by memo number ATO to recast the estimate in the light of the order passed in this case, estimate under new act is not applicable in this case. My lord, that is old Act, according to old Act, estimation is was. But the officer, my lord, calculated the estimate of old new Act.
This issue has been settled already.
Yes, my lord. So, my lord, now you wanted to file this application, my lord, you wanted to get 9 lakhs and other things. That is all. As directed administrative notice of the place estimate was forwarded to the joint secretary and the additional copy of the same matter. After receiving weighted estimate, that is the estimate, that is now the money is department guide number amounting to rupees 2,83,450 and weighted subsequent additional estimate 25,833 from LR department by memo number is amounting to rupees 3,09,280. 2,83,450 and weighted subsequent additional estimate 25,880 and total is 33. We paid him 3,09,000. Now he wanted the money the new act, according to the new act. But on that day when the order was passed, man, that is your lordship that to pay the money according to the old act estimation. And our officer made a mistake.
No, that part is clear already.
Yes,
The court has held that.
In spite of that,
It was not vetted. That part is all right.
Yes, madam.
But in the present writ petition, the memo dated 1st April 2022 is under challenge.
Madam, that is the amount.
No, this is a different amount. That's why I want to know what.
Department amounting to rupees.
What is this amount?
That is this.
No, this amount is no. This is 3 lakhs something.
3 lakh total is 3,09,000. That
Yes.
is after receiving weighted estimated LR amount department number amounting to rupees 2,83,000 of 450. Malady your lordship see on that part 2,83,450 and weighted subsequent additional estimate from LR department, RR department, that is by order number, that is total amounting to rupees 3 lakh. Well, on that day, your lordship showed me one, that is 2,83,000 of 450 and 25,833.
So the total totally coming to 3 lakhs 9.
And that part was, my lord, I find in the compliance report, I find this petition.
Yes, yes.
And on seeing this, my lord, your lordship passed the order. In spite of that, as there is a giving a liberty, only for that, my lord, he agreed, he filed this application.
Let the petitioner clarify this point.
Yes, please.
You have received that 3 lakhs and all.
Yes.
So now what is your further prayer?
Further prayer is that, my lord, pay
9 lakhs and that is turned down by the court. The court says that it is sufficient compliance. That means it is over. That part is
Your
over.
lordship granted liberty, my lord, pays 45, my lord.
Yes,
If
granted.
others amount is there, my lord, it will be reflected in the memo, my lord, because, my lord, this is the awarded amount. You will give in, my lord, the awarded amount. Subsequently, it was changed, my lord.
This is under the 1894 Act.
Yes, ma'am.
You are claiming under the 2013 Act.
13 Act.
So please substantiate your case. How are you claiming under the 2013
My lord, they have not deposited the money previously, my lord. Case was started long ago, my lord. They have not deposited the money in the court. They have not passed any award, my lord. Your lordship passed an order, thereafter passed an award, my lord. So, my lord, it is a new act. They will calculate it in new act.
an exception to the report?
No, my lord. I just leave maybe granted to file an exception to the report.
That's what I'm asking. Will you use an exception to the report?
Yes, ma'am.
Because you have to substantiate your case.
Yes.
They are claiming under the new act since before one.
Because, my lord, your lordship was according to my lord, then, my lord, we have completed all the calculation things, my lord. Report 2000. That is 13 Act.
Award has to be declared.
Award was declared before that. Your lordship was pleased to direct us, direct the authority.
1115, isn't it? That's the 2013 Act.
My lord, he can't claim.
Was the award declared prior to 1115?
Yes, my lord. 1140, 2040.
Please, where is that document?
Yes, my lord. That order, your lordship.
Please let him come back with an exception.
Yes,
We'll
yes.
deal with it. Learned counsel for the petitioner seeks to use an petitioners seeks to use an exception to the report submitted on behalf of the state respondents. Report has been filed today.
Yes, my lord. Report filed today.
তার আগে করুন affidavit of service filed by the petitioners and reports submitted by the state respondents are taken on record. তারপরে seeks to use an exception to the report, to the said report করে দিন তাহলে খালি to the said report. Paragraph, let the matter appear under the same heading on 25th January. Please serve an advance copy so that we can deal with the matter. Under the heading motion. Under the heading motion.
Item number 500.
25th January.
No, I am for the petition, my lord.
And I'm appearing for the state respondent.
This is my immediate service, my lord. The petition, my lord, my lord, on land has been acquired by the my lord authority concerned, my lord, since long. No, lord, I was not getting any my lord records, so I could not, my lord, come to the court or my lord, to the authority. My lord, then my lord, kindly see page 20. My lord, under RTI, my lord, I made application, and they said that it has been acquired, and 21 they are saying that no commission has been paid. Page 21. There, I have made application before the authority concerned. That is page 23.
Compensation has not been paid.
Not in paid. There I have made application, my lord, page 23, my lord.
Yes. This is not considered?
This is not considered, my lord. No award.
Considered? Affidavit of service. It is submitted on behalf of the petitioners that in response to an application
Under RTI Act, my lord.
filed by the
Page 20.
first petitioner under the Right to Information Act 2005, the he was informed that the plot in question was included in the acquisition schedule of LA case number 44 of 1978-79, arising out of LA case number 122 of 1973-74. Stop. A further reply to an application under the 2005 Act indicates that no compensation appears to have been granted in respect of the said plot. Stop. The petitioner submitted an application before the concerned authority on 6 June 2023 requesting payment of compensation, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the
That's one of 3, my lord. That's one of 3.
application
My lord.
at the earliest. Paragraph. Learned counsel for the state respondents submits that the third respondent be directed to consider the application in accordance with law. Paragraph. In view of the above, the petition is disposed of, directing the third respondent
Number 3.
consider and dispose of the representation submitted by the petitioner dated such and such within 2 months. Within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, in accordance with law. Paragraph. In the event the petitioners are found entitled to compensation, such compensation be disbursed in their favor within a month thereafter. Yes,
Respondent 3, my lord. Respondent 3.
yes, I've recorded it.
My lord, get full to us.
Next.
Item number 515.
My lord, I am for the petition, my lord.
For the state.
This is an application, my lord. Where, my lord, my lord, before in front of my land, my lord, there is PW land. My
Where
lord,
is the affidavit of service?
my lord, affidavit of service, my lord. This is my affidavit of service, my lord. I have served upon all, my lord, they have received the same.
Have you served the Panchayat, Jela Parishad?
My lord, upon all, my lord, all of them received the same, my lord. My lord, I have made representation before the authority concerned.
Please give me a minute. Have you checked that the service has been made?
My lord, I have confirmed, my lord.
Yes.
I have all services have been confirmed by the post office.
Panchayat has not been served. Where is the private respondent? Service Vishwakarma Puja Committee.
Served, my lord, it has served.
Do you have a copy? Please show me where is
My lord,
it.
it is, my lord, copy is not with me, my lord. Down I copy, xerox করে রাখেন না। xerox করে রাখতে বলে এই জন্য
Please show me service. This is only wasting time of the court. Panchayat and Vishwakarma Puja Committee.
গ্রাম পঞ্চায়েত, জি গ্রাম পঞ্চায়েত।
Is it written service or dispatch to BDO? Yes.
Lord, let me not today, my lord.
Yes.
Lord, let me not today, my lord. Let me not today, my lord. My lord.
After vacation.
Lord.
Since service upon the 9th and Rajiv, since service upon the 9th and 11th respondents is not complete, comma, let the matter stand over till 25th January 2024. Next.
Item number 516.
Well, I am appearing on behalf of the petitioners, my lord. I am led by Mr. Sarwar Cha.
Mr. Oil Banerjee for the state, my lord.
I am for the statement.
I am appearing for the
My lord, the petitioners are complaining the allegation of illegal
Address it all?
construction.
Yes.
The petitioners are alleging, my lord, illegal construction of the private respondent, my lord, obstructing my ingress and egress, and my lord, they are constructing upon the plot of land which belongs to the my lord state government.
Not PWD, it's government land.
Yes, my lord. My lord.
Not PWD. PWD land or
No,
government?
no, not my lord.
Government land.
Government land, my lord.
This is the
Page
report.
20, my lord.
You are
This is my
appearing for
complaint.
8 and 10. What about 9? Who is appearing for 9? Where is your affidavit of service?
Yes, my lord, it is in the record, my lord. All have been delivered, my lord.
Nine has not been served. The envelope says no such person at the address.
Then my lord gave me liberty, my lord, to file.
Please serve and come back.
My lord.
Otherwise, this
lord.
will come back again.
This is my. I have filed the report, my lord.
What does your report say?
Report said, my lord.
Report says, my lord,
Yes,
report says that, my lord, the plot of land belongs to government, and there are some constructions being made. But so far as not the obstruction of ingress egress, that is not correct. That is not correct. There's a map, but government land has been not used.
Any steps taken?
But steps they have not initiated, my lord, since matter has been filed, so subject to directions of the lords, we shall take steps.
In the report, my lord, it is also mentioned that the petitioner of the instant detention have claimed to be a patta holder over the suit land, but till date, the total plot is recorded in favor of state of West Bengal.
Well, one decimal plot of land has already been settled in favor of us, my lord.
In
And we are,
my lord, it was
and we are
mentioned.
deciding in the house, my lord, allotted to us under the scheme of Banglar Griho.
Submitting the original, the respondent number is not the as alleged in the petition matter. Originally, the Maniknagar Gram Adon Puja Committee and Mela Committee in the
is occupying
the land, and under them the Murshidabad, the money. The Anand cooperative counting that Adhuja committee and Mala committee. I am working as a Kormochari under the Anandanagar Milk Producer Cooperative Society. I am a Kormochari.
So you will not be affected at all if there is a removal.
Most interesting, my lord, I am working till March 2023. This writ petition has been filed September 2023. I have left that cooperative society. Now I am posted in another job, my lord, another society, posted at Barampur, my lord. And so far as regards the chain is concerned, my lord, they have similar cause of action against filed this application against the respondent number 10, and they have already withdrawn the allegation as against the respondent number 10 is concerned, my lord.
Where is that document?
My lord.
Yes.
That petition,
You have the document with you?
yes,
Please show me.
copy of-
The earlier writ petition? So this will be dismissed on suppression of medical material facts.
My lord, kindly see the order. The order.
কত নম্বর এটা?
I want to see the parties.
Respondent number 20, my lord.
WPA নম্বরটা কত?
Molloy Mondal. That is the respondent number 10.
WPA number Kartik Chandra Das, the same.
Respondent number 10 in the earlier writ petition.
Earlier petition, this one number
20. Present writ petition, respondent number 10 is appearing in earlier petition as respondent number
Molloy Mondal is 19.
90.
Have you mentioned this in your present writ petition?
My lord, I have not been instructed,
This
my lord.
is for suppression of material. You have not come with clean hands.
My lord, kindly tell me.
Yes?
I'll adjourn it for day, my lord.
No, no, no
I will take
question.
instruction, my lord.
It is very clear from the record itself. Dispute amicably settled and the petitioners have no further grievances. I can allow you to withdraw. I'll dismiss it here and now.
Hey, my lord.
You have not come to court with clean hands at all.
I don't. I will have to want to take
The
instruction.
status of the petitioner. That is, they are stating in the petition that they are the patta holder. That is also under
That this the writ court cannot decide.
It's not.
Yes, what
No,
will
no,
you
not
do?
press, my lord.
Yes,
I will not press, my lord.
you will not press.
Yes, my lord.
Very well. You can take back your report. Shall I keep it with on record?
If your lordship please.
Suppression of material facts, Mr. Banerjee. The report submitted on behalf of the state respondents is taken on record. Learned counsel for the petitioners submits that the petitioners do not intend to proceed with the matter any further. Paragraph in view of the above, the writ petition being such as dismissed for non-prosecution. There shall, however, be no order as to cause. Website copy. You can take back your documents. Next. Your report is on record. I have taken it. ওটা file এ থাকবে।
May I get a report, my lord? May I get a report?
Yes.
Item number 517. But I for the writ petitioner, this is the affidavit of service. There is no private respondent, only the state is the only respondent. My lord, here the very short question, I'm alleging a very short point, my lord. There is a plot of land. Lease deed was executed, registered. The land was utilized with construction. My lord, according in the lease deed and in the lease agreement, there is a provision for transferring the lease, my lord. And in the lease deed, it is specifically provided that without taking any permission, prior permission, and it will be granted permission subject to the availability and subject to the applicability of the present rules. Now, my lord, I have submitted, my lord, firstly, lordship kindly come. Page 24 of the writ petition.
Yes.
Yes, my lord. Your lordship will find subclause F.
Yes.
Not to transfer, assign of the leasehold interest without the previous consent in writing from the government. The decision of the government shall be communicated to the lessee within 30 days, my lord. Now, my lord, this is the lease agreement, my lord. It was accepted. And in the lease deed, your lordship, there is also a provision. If your lordship kindly take trouble, page 33.
Yes.
My lord, last subclause Roman 13. Not to assign, transfer, or part with possession of the demised land or any part thereof, or the structures erected thereon without the previous permission of the government in writing, and strictly in accordance with the government order made in this behalf from time to time, subject to the government's right of preemption. Now, my lord, my application, my original transfer is application submitted. If you also kindly take trouble, page 38.
Yes.
This was submitted on 11th January 2002.
Who is Sunil Chandra Sengupta? The
He
petitioner?
was the original allotee and the lessee. He was the original allotee and the recorded lessee. Now, due to his demise, his wife and daughter is now the present legal heirs and representatives, my lord. Well, they have already granted, got the mutation, my lord. Number 11th January.
Wife and daughter are the petitioners.
No, present petitioners are the persons who acquired this plot of land along with the construction by virtue of a registered deed of transfer. The registered deed of transfer was executed and registered after submitting of the application for transfer. This was not disposed of within a period of 1 month. Government did not take any decision.
Is there a clause that it will be deemed to be as accepted? If
Well, there is a clause. It is not deemed provision, but the government can regularize this type of transfer upon realizing the permission fees.
Clause?
Lordship.
Where is that clause?
Lordship. Lordship. Just now I am reading the lease deed. Lordship, kindly turn page 33.
Yes. Yes, 33.
Not to assign, Roman 13.
Yes.
Not to assign, transfer, or part with possession of the demised land or any part thereof, or the structure erected thereon, without the previous permission of the government in writing and strictly in accordance with the government order made in this behalf. Now, Lord, the government order I am showing, my lord. Present government order. My lord, this is the gazette notification. This is in force. They will take the permission fees, and I have already submitted my consent at page 62 that I am ready to pay the transfer permission fees in the year 2021.
Where is the regularization part? You have transferred without consent of the
No,
government.
my lord, they did not give the permission. Within 1 month in the lease agreement was the concluded
Does the deed
contract.
say that if they do not grant permission within 1
No,
month,
but
it will be deemed to be granted?
it was specifically written that the government shall, the word shall was used, shall grant the permission within 30 days, my lord. My lord, I have covered by the division bench judgment regarding same issue, covered by the single bench judgment, similar same issue.
Please show me the judgments.
Lordship. And this is a notification, my lord, on the basis of
With regard to the
transfer. This is regarding transfer.
yes.
Lordship, this is regarding transfer.
We are on permission. We are not on the fees.
My lord, the first division bench judgment, if the government stands idle for the years of year, my lord, this is
When was the application made and when was the transfer made?
well, my lord, application was submitted on
For years.
application submitted. Lordship will find at page
38 is the
page 38. They took the money, transfer processing fees. Lordship will find.
11 January 2002.
Thereafter, they took the money.
When did it transfer?
It was transferred on 2000. Lordship will find page 41. Fourth day of September 2003. Lordship.
Not even just 1 year.
Within 1 year, naturally.
So the judgment says just now you have referred.
Lordship,
years
I'm
together.
giving.
It says years together.
I'm giving, my lord.
I think please come back on the next date.
Tomorrow.
Not tomorrow after vacation. There is no tomorrow now.
My lord.
Next day.
Do you want to come back with a report or is it not
Lordship,
necessary?
I have a instruction, Lordship.
Will you file that?
Lordship, I
Because you need to give a copy to
Lordship,
learned
Lordship,
counsel so that he can go through it.
have to submit the instruction, Lordship.
Lord, may I get a copy?
Take a copy and please go
Copy
through it.
My lord,
Written instructions submitted on behalf of the.
my lord, can you allow me to, at least, if necessary, to come with an exception at least?
Is taken on record. Paragraph, on prayer of the petitioners, liberty is granted to use an exception to the instruction, comma, if required. Paragraph, heard learned counsels for the parties. Paragraph, let the matter appear under the same heading on 18 January.
As your lordship.
15 January.
এটা কি অরিজিনালটা কপি ওদেরকে দেওয়া হয়েছে ব্যাস তাহলে গল্প শেষ
Please call the witness, please.
Court applications under Article 226, item number 1, Uttam Nandi.
Mala, this is my lord, the report pursuant to my lord's order. Now, Mala, in the report, my lord, it has been specifically stated that they have been asked to come with, my lord, the requisite papers and documents with regard to their vehicles that they want to place. My lord, they, my lord, even my lord, today I, my lord, over telephone, I, my lord, wanted to know whether they have come because the permit is ready. Unless they come and, my lord, they collect the permit because, but still, my lord, some papers they have not yet produced. Requisite papers. My lord, it has been stated. Now, my lord, up to them whether they would collect the permit or not. Even paragraph 5, it has been stated also. Because when offer letter was issued, now it is their obligation to place the vehicle and the, my lord, the requisite papers. Now, they have to satisfy them, my lord, the authority.
Vehicle has not been placed.
The paper, they said that they produced some papers with regard to the vehicle they wanted to produce.
Other papers are necessary.
Now the other paper and the original should be placed at least for verification. For that, they have to meet with the, my lord, the officer concerned.
Is a date fixed for?
Well, let them go, my lord, any day.
No, that cannot be. Your lordship kindly fix it today, and your lordship will find everything has been produced, even the fees has been deposited.
Unless
Now let
the
them
original produced before the authority.
Original in respect of the vehicle. I'm not done. Let your lordship kindly fix the date. He will. They will.
Yes.
He will go. And this paragraph 5. This has been whether it has been served upon them or not. My client, because this is a statement hearing.
No statement. It has been served by affidavit.
Received a copy? So
Yes.
please instruct your client accordingly.
Then that I.
Let him go with all the relevant documents, all the originals.
In the meantime, Mala, if they wish, let them go. Mala, produce the original papers.
Yes.
And upon satisfaction of the same, the permit will be handed over. Or my lord can dispose it of also.
I'll dispose it of.
Yes.
No need of keeping
My
it
lord,
pending any
my lord,
further.
my lord.
The petitioner has prayed for issuance of stage carriage permit in his favor. For the route Chittoranjan bus stand to Digha Central bus stand. That is the route.
Bus terminus.
Chittoranjan bus stand to Digha Central bus stand. Paragraph. আচ্ছা একদম প্রথমে লিখুন report in the form of affidavit submitted on behalf of the respondents is taken on record. Paragraph. Placing reliance on the report in the form of affidavit submitted today, comma, learned counsel for the respondents submits that the permit is ready and the petitioner is required to approach the authority with all relevant documents in original for receiving the same. Paragraph. In view of the above, comma, nothing further remains to be adjudicated in the writ petition and the same is accordingly disposed of.
Good.
Paragraph. The petitioner is at liberty to approach the authority with all relevant documents. The petitioner is at liberty to approach the authority. Who should be approached?
The Secretary, State Transport Authority.
The authority,
Respondent
comma,
number.
being the
Respondent
fourth
fourth
respondent herein with
fourth.
all relevant documents in original within 1 week.
Up to him.
Yes.
Any day, you will.
Within a week,
Within 1 week from date. Stop. The fourth respondent, comma, upon verifying the documents produced by the petitioner, comma, shall consider issuance of permit in his favor.
Your lordship, they have already, upon being satisfied.
The fourth the fourth respondent, comma, upon being satisfied with the documents produced by the petitioner, comma, shall issue permit in his favor on the same date or within a week thereof.
No, then it would.
Thereafter, my lord, immediately, I think shall hand over the same. Only thing is that because this is the ministerial job.
On the same date. Paragraph, with the above instruction, the writ petition is disposed of. There shall, however, be no orders to cause which are till and since no affidavit or urgent certified website copy.
Grateful. Grateful.
Election petitions, item number 2, Manos Mojumdar.
Yes.
Lordship, I'm praying for accommodation for Lordship. Lordship, may kindly take the matter at 3:30. Lordship, that.
Not possible.
Lordship, that.
Strange requests being made. I don't know.
That-
Lordship
that's
does
the
not have any
reason
other
why I
matter.
did not fix at 3:30. That's the reason.
Lordship, may kindly.
I
We
had
cannot
made it very
expect the
clear
bench
on
to
the
sit
earlier
at
date.
our convenience.
I had made it very clear on the earlier date, isn't it?
That Lordship may kindly then accommodate for today only at least.
It's very difficult, my lord, to indicate this to my client. I have told him repeatedly, if you don't want to do it, inform me in the morning. Tell the gentleman not to come.
He
My lord, he
travels
takes
from a distance.
4
yes,
hours,
yes.
my lord, for him to my lord, reach court. He waits here, my lord. He is diligent every day. He is there.
It's not the fact, my lord. On the previously, Lordship, on several occasions, the witness was also not here. Lordship.
Let him show from records that Lordship has recorded my witness is not there and therefore adjournment.
That was
has been taken.
That has happened on 1 or 2 occasions, maybe, but that's not the issue.
Lordship, certainly, that's not the issue. Lordship,
Because there are other witnesses also.
no, Lordship, that's true, Lordship. That I apologize for that, Lordship.
11 January.
Grateful.
Well, I'll just ask him, my lord. He is available, my lord.
On prayer of the respondent, the matter is adjourned. Paragraph, let the matter appear under the same heading on 11 January. I repeat, I am not fixing it at 3:30. Because
Lordship.
it becomes difficult. I have to wait for the day and then come back at 3:30 again. Immediately.
My lord, let
will
it
the
be
last
observed that
matter.
if, my lord, if Mr. Chatterjee is in some difficulty, somebody would continue with the cross-examination because witness comes. Otherwise, again, my lord, if he comes,
Lordship,
my lord, with the
I
same
shall,
prayer-
Lordship.
Or at least inform
Lordship,
a day earlier.
Lordship, I shall, Lordship. In that case,
That's
Lordship,
true.
on the
That was
next
also-
day, Lordship, if the learned counsel is not appearing, Lordship, or he is not available,
The matter
I shall
will be
continue with the matter.
2:30 p.m.
Lordship may kindly appreciate. I would have, Lordship, continued because this is cross-examination is going on, Lordship. Suddenly, I cannot.
I understand, sir. I understand, but then I had made it very clear that it will not be 3:30. It will be the last matter on the original
Yes,
side.
Lordship.
And
Yes,
you have seen the list yesterday.
Lordship.
So no,
So
there's no
sudden
reason.
Lordship, some problem with Lordship.
Please take care of this on the next
I,
occasion.
I,
So the
Lordship.
same submission is not made.
Definitely,
It will not be at 3:30. Let me be very clear. Because original side matters are very few.
Yes. My lord, he will be here before 2 o'clock. My witness will be here, my lord.
There may be difficulty for either of the parties. Please inform beforehand.
Lordship.
So that the witness doesn't start from his house.
Lordship.
On the earlier date at least.
Lordship.
Yes. And if he comes to court, it is expected that he'll be cross-examined.
Lordship.
Grateful, my lord.
Grateful.